Sorry to trouble your lordship. On APSC matter, I think on senior DK Mishra is arguing the matter. Possibly he'll take whole day.
He says half an hour.
Half an hour, I don't know. Well, only one request is being made. On Tuesday, my father's annual Shraddh is there. So Tuesday in the afternoon, I'll be able to come and do the matter. So rest, some lawyers are there. Even I 2-3 lawyers. I'm sorry, my lord. Otherwise,
okay.
I would have been.
It's okay because
But I anyhow, because I have told that it will be over in the daytime, morning half. So 2 o'clock I'll be here, my.
Okay.
Because my part I have already done. 2-3, it still take that day only.
okay.
Sorry for talking.
Only the request is to make it short because we are running out of
that
time.
no, your lordship, I'll make it very short. Sorry for
No, it's okay.
inconvenience.
It's okay. Yes.
Yeah, this lordship. Lordship, I beg to withdraw item number 1, lordship.
Item 1 you want to withdraw.
Lordship, there is a typographical error, lordship. Lordship may kindly grant liberty to file a
Okay, your name?
petition. R. Medhi.
Okay. Upon both as a representative. Upon instructions, Mr. R. Medhi, Learned Counsel for the petitioner submits that there are certain typographical errors in the petition. So accordingly, she is to allow her to withdraw the petition and to approach again. Prayer is allowed. Attestation dismissed on withdrawal with liberty as prayed.
On next.
Right, Mr. Lordship, I wait to item number 4 and he is for item number 5 minus. With the consent of the other party, let the matter be taken after 1 week.
Otherwise, the service is also complete. The respondent, the advocate for the respondent has come in the morning. Oh, he's there.
Okay. Oh, this
The
matter where the acquittal was there.
No, this is
Then?
not that matter.
Okay.
Here is normal matter 302. It has come up for consideration of the IA.
Aye.
We'll take it up after 2 weeks then, because we are hearing this APSC matters. We can't give next week. Also, is represented on the prayer made by Mr. M. Hussain, Learned Counsel for the applicant in IA Criminal 1255 of 2024. The matter stands adjourned today. List after 2 weeks on a date to be fixed by the registry.
I'm for item number 5, madam. What are text matter, madam?
4-5.
Obvious.
Obvious.
Obliged. Even to money.
Item number 2 for admission.
If you made a mention of this case, lordship, for hearing, but in this case, I have gone through the orders, lordship. On 27/5, rule was issued and matter was directed to be listed in hearing column. Even if your lordship will take up this matter, I am ready, lordship.
No, not today. It's 2 weeks. We are not hearing any other matter.
Basis again. One basis again.
Lordship, then a date may be fixed for hearing of this matter. Already a rule was issued in this matter, lordship. 27.
Basis again. Almost one of that. Hearing question. School issue. তো পড়া লাগে ওর কেসটি পুলিশ এইখানে তো ফিক্স লাগে ফিক্স এবং গন্ডগোল কেস
Also, as a representative, as the rule has already been issued by order dated 27/5/2024. This is the matter for hearing. In the month of July 2025, after the vacation, this vacation or date to be fixed by the registry.
Obliged, lordship.
Item 3 for admission.
Yes.
May please lordship. This is not expertly order, my lord, page 30, my lord. He appeared, my lord. Thereafter, my lord, he came across some, my lord, videos of some NGOs, my lord, that they will deal with the matter and circulated in YouTube also, my lord. And they meet that person. And subsequently, my lord, he remained absent. And thereafter, that person was also arrested by police, my lord, who circulated the videos, my lord. And petitioner was also arrested, my lord, in the 7th of August, my lord.
Petitioner has a television in our home.
My lord, in mobile, my
have-
lord, now everybody has mobile, my lord.
No,
And
everybody
you-
has mobile.
You, my lord,
Ask the petitioner to look at the advertisement of Amitabh Bachchan.
and I have
He says, इस्तेमाल करे,
I-
फिर विश्वास करे.
I have downloaded in pen drive, my lord.
No, you don't know. If somebody gives an advertisement, I'll do it. You have gone there, right place. Why you have a grievance now?
As a result, he is facing consequence, my lord. He's in jail.
Can't help it because we are not satisfied with the explanation.
I may be given a chance, my lord. And your lordship dealt with similar matter, my lord. Imposing some cost.
No, no. It's not a case of cost. It's a case of negligence. You
Loss.
know the consequences and you don't come.
Negligence, my lord, misleading by somebody, my lord. Because if you, therefore, my
You
lord.
see, under the Advocates Act, you cannot go to anybody else. If anybody does it, it will be touting.
Yes.
You don't, despite suffering a offense of tout under the Advocates Act, you have not made a complaint against him. So therefore, you went to the right person. That is number one. Second is that you say that the petitioner is has been arrested and he is now in detention center. Since when?
7th of August, my lord.
Since August. So August and now we are about 9 months.
9 months.
Nobody in your family is interested to proceed against this fraudster.
He was already arrested by police.
No, no, that's okay, but it is not on your complaint.
Loss.
So therefore, you are not aggrieved person. You are not satisfied with the explanation. This can't be accepted. It's not that the petitioner never knows that there is a profession called advocate. This is from which place?
Forfeiture, my lord.
Borpeta.
And
One
your
of the-
lordship's order only similar.
One of the celebrities, celebrity lawyer is from Borpeta, David Ledger. He's a household name there. Pass it on. Pass it on. We'll see. Oh,
Exactly similar.
We
my lord.
discussed
He
in
was
chamber.
also, my lord, misleaded, my lord.
কপি এটা পঢ়ি চাব পাৰিম।
In paragraph 3, my lord, lordship.
In this case, there was an opinion earlier opinion of 21/9/2011, therefore we interfered. We said that we are rejecting that plea. The opinion expressed by the court is when the petitioner goes to a person who is not an advocate, on receipt of summons of the tribunal, the petitioner has done so at his own risk. Therefore, on the said ground, the court is disinclined to interfere with the opinion. Nonetheless, on perusal of the materials appended to the writ petition, it is noted that the petitioner is relying on an opinion dated 21/9/2011, wherein the proceedee so-and-so is projected mother of the petitioner was declared not a foreigner. So these are different circumstances. We'll examine and pass orders in the chambers. Yes, Mr. Sharma, you are supporting Mr.
Yes,
Adi?
No lordship. No lordship.
No.
Not. When lordship opinion was passed in year of 2022 lordship, we never bothered about the case lordship.
Okay, we'll examine and pass
Yes.
orders. You're reserving it. But you'll get it not before Monday,
Lordship.
whatever we do, because in the second half we have some work.
Lordship.
Chamber,
Correct.
Mr. R. Ali for the petitioner.
After arrest, he approached before this honorable court.
Yes, item 6.
Next, your lordship. This IA civil number 4095/2024 is the substitution of writ petitioner, lordship. And already notice was issued on 21/2025 in the IA, lordship.
Just a moment.
Amila Khatun.
This is an application for substitution.
Yes, lordship.
We allow this application.
Yes. No.
But this is R. Chaudhary and counsel for the applicant. Respondents are there. Mr. Kuli on behalf of Mr. A. Ali. Okay. You are? What's easy? Okay. But there's a small technical hitch. You have to wait for few more days.
Lordship.
This is an application for substitution. In this application, you have made again the deputy commissioner party who is no longer exists. It is in the earlier writ petition. Earlier writ petition, we did not notice. We don't take what you call. We
District
don't
court.
raise objection to that. But once you are substituting, then it has to be a proper party.
Lordship,
If-
earlier 2018.
We understand, but now this has to be substituted because you see in the old writ petitions, we are not asking for changing the nomenclature.
Lordship.
But now this is a current application where the nomenclature does not exist.
Lordship,
Today I
Then-
can't
then your lordship may.
we'll permit you to do it by hand, you do it, but you'll have to give a what you call typed out cost title.
If your lordship allows the IA, then I can file amended cost title in the writ petition. In that case.
No, we
can
have
take the-
got very bad experience.
Lordship.
Having passed the order, then it was not complied with.
I think lordship. I will take care of that, lordship. If your lordship allows, already in the writ petition deputy commissioner, so we have written as deputy commissioner. We should
Okay.
have written as district commissioner in the IA portion, lordship.
No, we understand that's the difficulty. And it's current now, it will be district commissioner.
Lordship, in the amended
You-
text
you'll
title,
do
I
it.
put the district commissioner.
But don't default because we have a bad experience. Then suo motu, it has to be listed again. Again, the order has to be recalled. it leads to a lot of difficulty. There has been a default. We have bad experience. All are not very reliable.
Lordship, I'll take care of that.
Okay. By filing this interlocutory application, the applicant applicants have paid for substitution of their names on the death of their predecessor in interest, namely Ashad 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 Ali alias Arshad ARSAD Ali, who is reported to have expired on 25/10/2020, leaving behind the applicants who are the wife, married daughter, and the son of the deceased. Next para. It is submitted that the predecessor in interest of the petitioners was held to be a foreigner by virtue of an opinion dated 23/8/2018, passed by the learned member, Foreigners Tribunal, Bongaigaon number 2nd, Abhayapuri, in capital BNGN /FT case number 2896/2009, arising out of BNGN IMDT 45/2001. This is at page 4 of the IA. It is submitted that notwithstanding the death of the applicant's predecessor in interest, the right to sue survives. Next paragraph. The learned counsel appearing for all the respondents have no objection to the prayer made. Accordingly, the prayer for substitution made in this interlocutory application stands allowed. The three applicants herein are permitted to be substituted as the legal representative of the deceased petitioner in the connected WBC 7751/2018. Next paragraph. Having noticed that the Office of Deputy Commissioner from Bongaigaon, arrayed as respondent number 3 does not exist, we direct the learned counsel for the petitioner to amend the cause title of this interlocutory application as well as the connected writ petition to substitute the respondent number 3 with officer of correct designation, public nomenclature. Next paragraph. The same shall be done. Continue, same paragraph. The same shall be done by adding us fresh typed out copy of the cause title of this interlocutory application and the connected writ petition and hand it over to the AOJ FT section for being incorporated in this interlocutory application and the connected writ petition. Next paragraph. The issuance of certified copy of this order shall be delayed till correction of the cause title.
In the writ,
IA stands disposed of.
Lordship, in the writ petition, I will file amended cause title.
Yes. And the petition you say, all sides are represented by order dated so and so, passed in IA so and so. Substitution of the writ petition is allowed. Stop. The next paragraph, the learned counsel for the petitioner is also directed to to amend the cause title on terms as indicated in the said interlocutory order. Next para. Is ready for hearing otherwise?
Yes.
Let's hear is coming.
Earlier it was listed for admission, Lordship. Then it came for hearing under column C.
Just a moment.
Then the writ petitioner died, Lordship. Hearing at
So notice has not been issued.
26/11/2018 LCR called for stay granted, Lordship.
No, whatever has happened, but notice has not been issued. Okay.
Yes, Lordship.
Mr.
White 26/11/18.
No, stay is something else, but there's a specific order.
Lordship.
List the matter in
Yes.
motion on so and so as we propose to examine the case record before issuing notice in the case.
Lordship.
So therefore, notice has never been issued. In this case, there's something on record by virtue of which the court has recorded that the Standing Council for the Foreigners Tribunal and Border Areas has contended that there is nothing on record to show that Arfan Ali, son of Asan Ali, and Arfan Ali, son of Asan, are one and same person. So you'll have to look at the record and address us on that. You take it up on motion next week. Just go through the records. Next para. In the writ petition, you say it appears from the order dated 26/11/2018 that the court had proposed to examine the case records before issuing notice in the case. There is no order of issuing notice of motion in the matter. Accordingly, list the matter in the motion column. Make it make it Friday next.
Though no notice was issued on 4/1, it was stated that list for admission hearing, Lordship.
I understand, but there's a
But notice was not issued till from the very first.
Mrs. Chaudhary, what happens is that I have a bad habit of looking at previous orders and the office notes and then proceed with the matter. At times we miss it. If there's no assistance, we miss that notice has not been issued. It's a specific order to hear on the issue raised by the respondents that the Asan Ali he's not so and so.
Lordship, on next Friday, after amending the cost title, Lordship. Obliged.
Yes, item 7 and 8. Ms. Jan, you are waiting for which item? Ms. Jan, you are waiting for which item?
No, Lakshmi, I was waiting for the PSC matter because Mitra sir is coming little late. So he was under the impression it will start at 2. So if it starts before that, so I'm waiting. because-
Then you will continue.
I'll reprise your Lordship.
Okay.
So is this step stopgap?
Huh?
Stopgap.
Okay, arrangement. Lordship.
There is another name in cards, but when somebody plays cards, there is another name for that.
My lord, at the outset, I express my sincere gratitude to given me opportunity to heard my case. My lord, I'm respondent of respondent number 1 of writ petition 142 by 2023 and respondent number 6 of item number 350 by 2022. My lord, I am representing in person. My lord, my name is Dipankar Das. I am born and brought up from a small town of Assam. From my college time, with okay.
Address on the merit of the matter.
Yeah. My lord, I applied for this post assistant executive engineer at IIT Guwahati. Wide advertisement dated, which may be seen in the page number 47, my lord. My lord, I request you to draw your kind attention on the page number 47, serial number 3. Assistant executive engineer, in bracket, it is written civil.
Just a moment. You see, Mr. Sabua has already addressed us on the merit. You have something more to add?
Yes, sir.
Because you may not repeat whatever is already stated by Mr. Samua. Yes.
Yes, sir. Sir, by scene itself, I request to kindly have a look, sir. Assistant executive engineer, in bracket, it is written civil. Civil, initially by seeing any candidate, you will understand that the post is for the civil engineer. It is not for the civilian. But in the advertisement, it is mentioned that bachelor or equivalent degree in the engineering from a recognized university. My lord, every IIT comes under the Institute of Technology Act 1961. And IIT Guwahati is established under the Amendment 4, Clause 2. My lord, please refer the IIT Act, page number 95, my lord. As per the Act, Clause 6, 1H, it is mentioned that the page number, I request to refer the page number 102. Clause 6, 1H, that it is mentioned to institute academic and other posts to make appointment thereto. That means all institute, they have to make their own academic and other posts to make appointment. My lord, this has been given elaborately by the ministry letter, which may be referred in page number 134. Ministry of Human Resource Development, technical section, they have written to all IIT director, my lord, page number 134, that creation of non-faculty post at IITs as per the Act 61H. Here it is mentioned that IITs are allowed to design their administrative, management, technical staff structure as per the requirement after due approval from their board of governing body. That means, my lord, IIT need not go to any UPSC, APSC, SSC for their creation of post and the appointment of the post. They can create their own post with the recruitment rule approved by the board of governing body. My lord, similarly, IIT Guwahati, they have placed the recruitment rule in their 80th Board of Governing Body meeting. My lord, please refer the page number 134 on 3rd March 2016. On 3rd March 2016, IIT has put the recruitment rule in the 18th Board of Governing Body meeting. My lord, I request to kindly have a look on the serial number 6. The name of the post is Assistant Executive Engineer and
Which
serial
page? Which page?
138, my lord.
Yes.
My lord, in the serial, the name of the post is Assistant Executive Engineer Civil. But in the serial number 6, it is written that bachelor degree in civil engineer and bachelor degree in the electrical engineer. My lord, in any IITs, the there is only two post exit. One is civil engineer, one is electrical engineer. Civil engineer will look after all the infrastructure project, road, building, drain, etc. And electrical engineer will look after the all electrification, AC, and all the light and laboratory. My lord, in at IIT, there is no other post exit, like for example, aerospace, metallurgy engineer, nothing. Only two post is exit, my lord. And in their 18th board of governing body, they have
We are
placed
not being able
this,
to follow you. What is section 6 you are referring to? Section 6 is not here at page 138.
serial number 6, sir, education and other qualification.
Something is wrong. You are referring to which rate petition?
350 by 2022.
350.
Yes, my lord.
See. Keep on going. Yes.
Yes, my lord. My lord, the recruitment rule has stipulated the qualification, that is bachelor degree in civil engineering and bachelor degree in the electrical engineering. As the advertisement has called the assistant executive engineer civil, therefore the qualification must be bachelor degree in civil engineering, not bachelor equivalent degree in engineering, what has mentioned in the advertisement, my lord. My lord, I am there are many Supreme Court judgment. I am rely on the Supreme Court judgment. I have copy, my lord. This is a judgment by the ESIC and the Union of India. My lord, I have the judgment copy. I would like to quote the paragraph of this judgment copy, my lord. Is it honorable Supreme Court division bench judgment, my lord? Is the page number H, the serial number is 11, my lord. The line number 4, it is mentioned, it is settled law that if any advertisement is inconsistent with the recruitment rule, the rule could prevail, as held by the court in Malik Mazhar Sultan UPSC and Ashish Kumar versus State of UP. My lord, therefore, my submission is, as the IIT is formed under the Act of Institute of Technology Act, and the recruitment rule is approved in the 18th Board of Governing Body meeting, But in the advertisement, it is mentioned that bachelor degree in the education. My lord, and another things, I have submitted my, during the uh, counter affidavit, I have requesting to kindly refer the page number counter affidavit. 360, my lord. My counter affidavit, I submitted 360 page number. My lord, in the table, I submitted one table, my lord, as per the recruitment rule, which is a statutory in the nature, and the advertisement dated 25/11/2016. Age for the direct recruitment. My lord, this is a direct recruitment, my lord. At IIT Guwahati, 50% seat is reserved for the direct recruitment and 50% is the promotion. So direct recruitment means equal opportunity should be given to the all over the India candidate. So my lord, I have made one table where you can see the age limit for the direct recruitment is 35. But in advertisement, it is one line is added that internal candidate minimum requirement pertain to the age may be insistent upon. My lord, it is added in the advertisement, despite it is not there in the recruitment rule. Further, my lord, education and qualification. As the post is called for the assistant executive engineer civil, therefore it must be bachelor degree in civil engineer, at least 6 years experience. But in advertisement, it is mentioned bachelor or equivalent degree in the engineering from the recognized university.
You are reading from where?
Counter affidavit, my lord.
Where, which page?
360.
Doesn't match. Whatever you are reading is not there at 360.
My lord, maybe on the, it has filed on the read appeal 342. May please,
342.
yes, my lord.
There is no 342 here.
342, page number 360.
There is no 342 with us.
142, my lord, read appeal. But IIT Guwahati versus Dipankar Roy.
If you have to tell us the correct page, then only we'll see.
Sorry, my lord.
There is no 360 here. ये तो देखा क्या?
Yes, my lord.
When did you file it? It's there on the report.
Yes,
What is the page?
they are, I think, 460.
460.
January 2023, I find.
Yes.
My lord, I have categorized, mentioned the recruitment rule versus the advertisement. My lord, recruitment rule, which is a statutory in nature, there in the recruitment rule, age limit for the direct recruitment is 35 years. But it is mentioned in the advertisement, it is mentioned 35 years, below 35 years for internal candidate minimum requirement pertain to age may not be insistent upon. This has been added additional. Apart from this, education and other qualification required. As per the recruitment rule, bachelor degree in civil engineer with at least 6 years working experience. Here, my lord mentioned bachelor and equivalent degree in engineering. Civil engineering was not mentioned, my lord, in the advertisement.
Yes, so that would be good. You report of this. Okay, but you want to assume that your file will come. Do you have a copy?
Yeah.
To the live today.
Yes, yes.
Pilot amount of night. Open easily and get it. You. On a file, please. Review the summary for respondent number 6. Respondent number 6.
Mine.
6 to get. Your file was a account.
January 2023.
You see, we are unable to express, accept your argument insofar as the qualifications are concerned. Number one, in the prayer in your writ petition, you have not challenged the advertisement or the qualification itself. So this is something which we can't enter. You are merely saying that you cancel his appointment. That is the simple prayer.
My lord, in my writ petition, I have added the age criteria also.
The advertisement or the conditions of advertisement has not been challenged. Come to page 43 and 44. That is your prayer. Your prayer is not to not that the advertisement itself be set aside, and along with it the recruitment done. You are merely saying that to set aside the impugned selection and appointment of respondent number 3. That's all. This is something we will not enter. Once this advertisement challenged, that's why we said that Mr. Sharma has made his submission. If you have something to supplement it,
Okay.
please do.
Okay.
This is something which is not acceptable.
Yes, okay.
The
lord.
legal proposition is that once it is not under challenge, the IIT will not, must not have responded to it, and therefore, in a writ petition, we can't decide the issue which is not raised and agitated. You see, we have no reason to tell you what we are thinking, but we are doing so just because since you are a respondent in person, you must know what is happening. Only to bring some transparency, we are telling you. Otherwise, we are not obliged to tell you what we are thinking.
Understand. My lord, as per the BS engineering technology, being a respondent, I have not argued that this course is not approved by UGC, AICT, and Joint Committee. I am agree. This course is approved by UGC, AICT, and the Joint Committee. But the thing is, BS engineering technology, whether it is a degree or it is an equivalent to degree or not. So appellant has relied on the page number 291, my lord.
291, which writ petition? Which
350,
writ appeal?
350,
350. Page number?
291.
291.
Keep on. 91, 350 to that way, ना? तो वो ध्यान रखिए आप। 1.5 को सेवा में reply भी और नहीं कर
Yes.
My lord, this is an office memorandum issued by the BITS Pilani, my lord. This is a equivalency certificate course of BS degree. My lord, here BITS Pilani has issued office memorandum. My lord, BITS Pilani is a private institute, and they have issued this office memorandum for their institute only. It is no, it cannot be implies on the other government notification. My lord, I already submit one honorable Supreme Court bench judgment. My lord, in this judgment, I like to rely on the para number 8, where it is mentioned that it is settled law in the event of inconsistency conflict between statutory provision and executive instruction. This is called as an executive instruction, my lord. This is implies only at the BITS Filani for their admission purpose, my lord. In the last line, it is mentioned that this notification is not visible.
Yes.
My lord, in the last line, they have mentioned that it is for the admission purpose only. It is for the admission purpose, like BS Engineering Technology, they can take eligible for admission in higher degree, like ME, M Pharma, MS. This is an office memorandum for their institute only. This cannot give equivalency certificate, my lord. This is an executive instruction. And I submitted honorable Supreme Court bench order, this para number 8, my lord. Here it is mainly mentioned that no statutory provision always prevail, my lord. My lord, my appellant's honorable respected senior counsel has that day on 8th May has submitted all the public notification of UGC and AICT, wherein, my lord, UGC and AICT given counter affidavit. So public notification will like have more value or not. Already my UGC respected counsel has told. And my lord, one more thing. So when during the argument, my respected counsel has submitted Honorable Supreme Court Orissa Lift Irrigation Judgment 2017. Then my respected senior counsel has told that this judgment cannot implies because the result, selection, everything has been done prior to this. My lord, then my respected senior counsel has submitted Institute of Eminent, which order given by government in the year of 2020. So, my lord, already in the writ petition, my lord, total 24 number documents submitted, 24 time hearing has been done, and after 4 years, 8 months, judgment has given considering the all documents submitted. So, my lord, my request is it comes under the principle of res judicata, my lord. My lord, I am whatever my submission I have given in my writ petition already and the writ appeal also. My lord, my simple humble request to my lord, after this result, my lord, I have written letter to IIT director, MHID minister, PMO office, where I did not get any response. Then I knocked the temple of justice, my lord. Now I am jobless, my lord, and I believe that honorable court will give justice in this case, my lord. My lord, for me now I am fighting for the survival and the livelihood, and this is my submission, my lord. And I'll conclude my argument, my lord. Thank you.
Yes, Mr. Mahanto.
The UGC council wants to show some decision. Let him. Beg your lordship's pardon, my lord. Another matter is on queue, my lord. After showing this, my lord, I would like to take your lordship's leave. My lord, that day I pointed out, I just referred to one judgment, but a copy of that judgment was not given. Today, I have given to the court master that judgments. On writ appeal 55/2019. My basic argument is as to the validity of the degree that was holding by the appellant, that is BSc in engineering technology. This is judgment.
Uh,
Has your lordship got it, my lord?
Yes, we've given two judgments. Writ appeal?
55, 2019.
Yes, we got it.
And the original judgment, the single judge judgment, 2983 of 2017.
Yes, we have it.
Lordship allows, my lord, if I can come from this judgment, my lord, where from this appeal, right, my lord, appeal was instituted. And in, this is my, by study, did this.
You said that
Research to more go in
I can show you.
Eto my this is sir. Eto this is my, eto koyo this is the ARA. Man, eto this matter. Soft copy this one. Yes, sir. Nice one.
Yes.
If I may take the single judgment, my lord. After reading this judgment, then if you read the division bench judgment, my lord, this will make the position clear. The subject matter of dispute in these two petitions being similar, the same are heard together and disposed of by this common order. The dispute in brief is with regard to the postgraduate degree obtained by the private respondents in both the cases from universities outside the state of Assam with their study centers in Northeast India. This is important. Mr. So the second paragraph I left, my lord. Paragraph 3, for a proper adjudication of the dispute involved in these writ petitions, a narration of the facts of the cases are given herein below. The petitioner in subdivision number so and so is a subject teacher and who was also holding the post of IC principal of so and so school. The petitioner claims to have passed all necessary qualifications to be appointed as principal of a higher secondary school, and the fact that she was already allowed to hold the charge of principal of the schools fortifies this claim. An advertisement was issued on 19/6/2016 for filling up of the post of principal of various higher secondary school, including the school in question, which was mentioned in serial number 4 of the list of the schools covered by the said advertisement. There is no dispute to the fact that the selection was to be held in accordance with the order dated so and so. In the ensuing selection, the respondent number 4 was selected as the first nominee and right order dated 2/5/2017. The said respondent number 4 was appointed as the principal. It is admitted fact that the said respondent number 4 had obtained his MA degree from the Agartala Center of Madurai Kamraj University. The aforesaid degrees obtained by the said respondent number 4 from an off-campus study center has been questioned in this proceeding, and the same degree has been argued to be an invalid degree. Same issue, my lord. The petitioner in WPC number so and so has approached this court with a similar grievance with respect to her school, namely Swarna Lakshmi Higher Secondary School, Narsingpur in the district of Kachar. It is the case of the petitioner that she, being the senior most teacher in the said school, having all the requisite qualification, was given the charge of the principal on the retirement of the earlier incumbent. She also claims that she was inducted as a member of the district level committee recommending names of teachers for study awards. She was also acting as a member of regulation of rational various teachers. We are working, well, I'm leaving this paragraph. As in the other writ petition, a requirement drive for filling up the post of principal of regular basis was initiated by an advertisement dated 21/6/16, in which the petitioner along with other candidates, including the respondent number 7, had participated. The interview was held on 10/1/17, and noticing that the MA degree in the respondent number 7 of the year 2013 was from Sam Higginbotham University Study Center at Silchar, the petitioner had immediately lodged a complaint on so and so date. However, by ignoring such complaints, the said respondent number 7 was appointed as the principal of the said school in question. Then, my lord, submission part I left, my lord. I skipped the page 7. Page 8 from paragraph number 13 onwards. Referring to the case of Orissa Leaf Corporation Limited, referred in 2018, 1 SCC 271. The Learned Senior Council has submitted that the direction of the Honorable Supreme Court in paragraph 5311 containing restrictions on all deemed university was to be given effect from the academic section 2018-19 onwards. CSO Learned Council representing UGC, however, has categorically submitted that degrees of the private respondents are not valid in the eyes of law. Referring to the affidavit in opposition of the UGC, the Learned Council has submitted that the restrictions are not new but were operating since the year 2001. In fact, the Learned Council refers to the communication dated 9/8/2001, wherein the UGC had instructed the registrars of all universities to stop franchising and that no student were to be permitted in such centers. A repetition of the said direction was given by Fight Communication dated 13/5/3 and 16/4/2009. The Learned Council has submitted that the following the law laid down by the Honorable Supreme Court in the case of Professor Yaspal, and to meet the object of the UGC, which is to maintain a high standard in the higher education, such communication have been issued from time to time. Countering the submission made on behalf of the private respondent, Learned Council for the UGC had submitted that even at the time when degrees in questions were obtained, the restrictions were fully operative, and therefore the said respondents cannot take a plea of being ignorant of such restrictions and of being victims of circumstance. Sri B. Sinha Learned Council appears on behalf of the Sam Higginbotham University, WBC number so and so, and admits of having centers at Kachar. However, the Learned Council on a specific query from this court was unable to answer as to what manner of control or supervision of the university had over the said study center. As regards approval by the UGC for distance mode of education, no such approval could be produced. Then, my lord, paragraph 18. The facts involved in these cases are not in dispute. The respondent number 4 in the first writ petition had admittedly obtained MA degree from Agartala Study Center of Madurai Kamraj University, which is in the state of Tamil Nadu. Similarly, the respondent number 7 in WBC number so and so has obtained his MA degree in mathematics from Kachar Study Center of the Sam Higginbotham University, a deemed university in the state of UP. The regulation promulgated by the UGC from time to time makes it clear that so far as the study center is concerned, it cannot have a study center outside from the territorial jurisdiction of the state, whereas for a deemed university, the restrictions are more severe in as much as there cannot be study center outside the campus of the deemed university, even in the same state. That day, my lord, I informed to the submitted before the sound report. The deemed universities cannot go beyond their campus. Even in their own state, they cannot. And even if they are allowed to operate a study center, that has to be, they have to have previous approval from the UGC. And it is on our categorical stand, not only BIS Pilani. UGC has never allowed any university to operate any study centers, to any university. In 2 cases, admittedly, there was no approval from the UGC or the Distance Education Bureau, earlier IGNO, and in absence of such approval, the postgraduate degrees said to be obtained by the private respondents are non-est in law. Then, my lord, the Honorable Single Judge has quoted the relevant paragraphs from Professor Yaspal in the previous in subsequent paragraphs and set aside all the degrees below. An appointment of principals were set aside. Now, this has been taken to an appeal. This is a page readable 55. I'll not take much time, I'll just point out the main things here. 55 of My lord, may kindly come to paragraph 5 of the appeal judgment. The respondent writ petitioners raised a plea that a person who has obtained degrees from study center operating outside the state where university is located would not be a valid degree for the purpose of considering eligibility for the post of principal. Learned Single Judge by the impugned judgment held that the selection is liable to be interfered with on the ground that the incumbents, the appellants before us, do not possess valid possess valid postgraduate degrees, which is an essential requirement under the rules. Consequently, their appointments as principal in the schools in questions were set aside, and the respondents were given liberty to fill up the post from the panel of selected candidates in accordance with law. For considering whether a degree is recognized or not, it would be most appropriate to refer to the affidavit filed by the University Grants Commission in both the petition. University Grants Commission. In both the petitions, the UGC brought out the facts and the legal position that UGC has never at any point of time granted the above named university to open study centers outside the states where they were located. For the purpose of exact reference, we extract herein below paragraph 8 and 9 of the counter affidavit filed by Mr. So-and-so holding the post of education officer in UGC so-and-so address on behalf of respondent number 8. The said paragraphs reads as under. That it is respectfully submitted that the basic issue that leading to the filing of the instant writ petition is that the master degree in economics obtained by the respondent number 4 from the Madurai Kamraj University, Tamil Nadu, under distance mode from an off-campus center in Tripura is claimed to be invalid. Thus, cannot be used for any purpose. This honorable court at this juncture implicated UGC as a party respondent and asked the UGC to clarify the aforesaid issue. The reply of the University Grants Commission in this point are as follows. Madurai Kamraj University, Madurai, Tamil Nadu is a state university. It can operate
You can
within.
omit that part.
Madam.
You can omit this part.
Yes, madam. Then after this, my lord, this portion of that affidavit of the UGC was quoted. Then that the paragraph 9, my lord, that the answering respondent on behalf of the UGC Commission, University Grants Commission begs to state that it is not a case that the University Grants Commission had issued only one directives, that is on 27/6/13, or for that matter, notice or notification, etc., as regards functioning of the UGC universities, which are imparting education in distance and open learning mode. It is utmost necessary at this point to make a mention of the notification issued from time to time in this regard. And here was an argument from my respected senior that the notifications, it was only issued in the year 2013. It's not correct, my lord. It is since 2001, the record, this judgment, it is single judge judgment and the division bench judgment of this case, same case, my lord. It shows, my lord, we had submitted the details before that court in that case, that it is from 2001, directing all the universities who is dealing with the distance open learning mode that don't operate any study centers. The UGC policies on territorial jurisdiction, study center, on-campus, etc. has been elaborated in various University Grants Commissions later. The public notice dated 27/6/13 was only reiteration of earlier policy of UGC on territorial jurisdiction of universities. The UGC White Circular number dated 9/8/2001 directed all universities as under. The universities can conduct courses through its own departments, its constituent colleges, and or through its affiliated institutions. There is, however, no provision for leaving it to private institutions for conducting course leading to award of its degrees. As per recent UGC guidelines, the universities were permitted to impart education and award its degrees through their own campus located elsewhere in the country or even at their own offshore campuses with the approval of the UGC. Looking into the widespread of franchising the university education through the private institution, the UGC has decided that any university which proposed to enter into collaboration with any private institution would be required to take prior approval of the UGC. The Commission has also decided that no university should be permitted to go for off-campus private educational franchise leading to the award of its degrees. Accordingly, all the universities are being directed to stop franchising their degree education through private agencies, establishments with immediate effect. On similar lines, the reply was filed in petition, which is subject matter of the writ appeal number 55/19. Considering the stand of the UGC to the fact that in terms of judgment rendered in Honorable Supreme Court in Professor Yashpal, the issue of territorial jurisdiction and opening study center has been clarified by the UGC. UGC from time to time has issued various circulars and direction beginning 2001. The said UGC circular has been extracted in para 9(1) above, which demonstrate that not only the applicants were not eligible to compete for the post of principal because they lacked the basic qualification, not having passed MA or MSc from UGC recognized university, but also the said circulars and notification has been circulated repeatedly since 2001. It stands demonstrated that the appellants in the two appeals obtained degrees from study centers located outside the states where the concerned universities were located. Hence, the said degrees cannot be said to have been issued by UGC recognized universities. Considering the said stand of the UGC as noticed above, we find no merit in these two appeals. Therefore, my lord, this is on record, my lord. That day I showed that page. It shows the degree obtained by yes, Sunirmal Bhattacharya is from Beach Pilani. He is an off-campus degree, my lord. Without even going to the nomenclature of the degree, that there is no, where it is unheard of, the BSc Engineering Technology, this degree is unheard of. Without going to even that part, Lordship can hold it. It is crystal clear now that having a degree from an off-campus study center is invalid. Thus, any subsequent actions, promotions, appointments are invalid. Lordship permits me, may I take leave? Obliged. Let the sorry, my lord, I arrived little late. I will start off in some way. My lord, I submitted earlier.
Your mirror image appeared earlier.
Sorry,
Your mirror image appeared earlier.
image. I submitted, I opened my argument saying that the learned single judge misdirected the whole outcome. It went astray. It seems the other side is still harping on that. I'm grateful that Lordship has pointed out certain things to the petitioner here, who took up the point relating to the degree and all. What is there in the prayer or in the writ petition? There lies the crux of the whole issue. Once more, kindly see. What is his case? His case is strictly that the selection and appointment should be certain. What is the basic issue? Basic issue is whether his selection is good or bad. Now, the process of selection is not under challenge. He says, what is his ground? He says that he could not have been selected because his degree is bad. Is there a direct challenge to the degree? Question arises. To question the degree, if it is the basic prayer, this is the primary issue, then in that case there must be a prayer to that.
No, he's not challenging the
Exactly.
He's not challenging the degree. He says
Exactly.
that the appointment is bad because the degree is invalid.
Appointment that indirectly he is challenging the degree.
No.
In my small submission, it amounts to a challenge to the degree that it is bad in law.
No.
Otherwise, how this honorable court will judge, look into the issue without giving the affected parties an opportunity. Who is the institution which granted the degree? Kindly see, Mala, the decision just now referred to by the Learned Council of the UGC. This decision, there the direct challenge was the degree. In that decision, the direct challenge, writ petition file challenging that the degree is invalid. And therefore, the institution which granted the degree should be noticed. Had it been the case here, the whole inquiry would have been different. That this, what they call it, BS in engineering technology, cannot be constituted to be a legal degree, even not equivalent to BE. So therefore, this could not have been the terms used, or that could not have been a condition citing qualification in the advertisement itself. Then question would have been different. They have not challenged that. Therefore, your lordship was very right in saying that you have not, issue is different here. You cannot argue that, you have argued, but we cannot consider. Rightly. When this is not the primary issue here, whether this court will go to a roving inquiry to look to come to a satisfaction to find out whether this degree was rightly granted or this has any legal basis or not. In my full submission, this is not permissible here. Therefore, I say that the issue was whether, because the advertisement is not under challenge. Advertisement said from a recognized institute. The degree from a recognized institute. It is not said that a recognized degree obtained from an appropriate or recognized institute. He has submitted to it. Petitioner has appeared in the interview. He has submitted to the process. In the result, he could not come out successful to his satisfaction. Therefore, he has come. Now, can he now turn around and challenge that no, the particular qualification mentioned there is not valid? He cannot. He cannot challenge that. Because he himself accepted it, participated in it. All people. And as I submitted on the basis of the decision of the apex court on the last occasion, it is for the authority, employer, to decide what is the qualification required and whether the qualification they have mentioned is just and fair or appropriate, rather. Therefore, in my full submission, the whole inquiry was diverted. To challenge the degree, if had there been a challenge, because it has far-reaching consequences. The university is pursuing this right from the year 1971. Is it? It goes to Petapa? 71. And so many people have passed out. Now, if it is to be said that this degree is invalid, the first and foremost requirement is to hear the bis Pilani. Bis Pilani is not a party here. Who are the party? Lordship may kindly see. IIT, then the AICTE, subsequently added UGC and AICTE, and two individuals, me and the other person who were selected and appointed. Therefore, sorry, this program was right from 1979, not 71, 79, at page 162, as I placed earlier. So, here, at page 43, Lordship may come to the paper book again. In the premises aforesaid, it is therefore most respectfully prayed that your lordships may be pleased to admit this petition call for the records issue rule calling upon the respondents to show cause as to why a writ in the nature of mandamus and or any other appropriate writ order or direction should not be issued to quash and set aside the impugn selection and appointment of private respondent number 3 and 4 to the post of Assistant Executive Engineer in Indian Institute of Technology, in short, Guwahati, with a selection result dated 4/5/2017, in reference to advertisement bearing number so-and-so, dated 25/11/2016. Pausing for a moment. This is the primary prayer. This is the basic prayer. Then, and to direct the official respondents to publish a fresh selection result to the post of Assistant Executive Engineer in the Indian Institute of Technology, Guwahati, amongst the rest of rank holders as per the selection result dated 4/5/17 to the post of Assistant Executive Engineer in the Indian Institute of Technology in reference to advertisement bearing number so-and-so, dated so-and-so, and your losses may be pleased to pass as orders as may deem fit, pending final disposal. It should pray that lordships may be pleased to pass an interim or direction directing the officials, respondents to keep in abeyance the impugned selection and appointment. Lordship will best appreciate that we know that primary relief and there are some consequential reliefs. Even consequential reliefs have to be prayed. But here, nothing. When his basic case is challenged to the selection and appointment, and while making an inquiry to this, the inquiry will be limited to whether any illegality or irregularity is committed in the process of selection, not beyond. Not beyond. Therefore, in the guise of, in my respectful submission, in the guise of looking into this particular aspect, even under 226, this honorable court will not go to declare a degree invalid. Number one, this is not the basic issue. Number two, there is no prayer at all. Number three, there is no sufficient materials, no pleadings to hold that the degree is bad. Therefore, my lord, my respectful submission, this court will not go into all these aspects. By arguing to that aspects, they are burdening this court unnecessarily. I am relying on the decision of the apex court. (2010) 1 SCC 234. Bharat Amratlal Kothari and another versus Dushukan Sadak Samad Khan Sindhi and others. Samad Khan Sindhi and others. Lordship, this one itu? Has got it, my lord. Yes. Huh? It is Jana? 9 year hard copy. Would the Pavol even? Lordship has got it.
Yes, yes.
Well, paragraph 29, Lordship will straight will come. 29.
Yes.
The approach of the High Court in granting relief not prayed for cannot be approved by this court. Every petition under Article 226 of the Constitution must contain a relief clause. Whenever the petitioner is entitled to or is claiming more than one relief, he must pray for all the reliefs. Under the provisions of the Code of Civil Procedure 1908, if the plaintiff omits, except with the leave of the court, to sue for any particular relief which he is entitled to get, he will not afterwards be allowed to sue in respect of the portion so omitted or relinquished. 30. Though the provisions of the code are not made applicable to the proceedings under Article 226 of the Constitution, the general principles made in the Civil Procedure Code will apply even to writ petitions. It is therefore incumbent on the petitioner to claim all reliefs he seeks from the court. Normally, the court will grant only those reliefs specifically prayed for by the petitioner. Though the court has very wide discretion in granting relief, the court, however, cannot, ignoring and keeping aside the norms and principles governing grant of relief, grant a relief not even prayed for by the petitioner. If Lordship may rise for a moment, my lord, they are waiting.
Yes.
This is the principle laid down. Because otherwise, my lord, there will be far-reaching consequences. If a particular relief is prayed, and in course of granting that relief, there may be the requirement of hearing so many things, so many affected persons. Therefore, court says that, CPC is definitely very definite. But here they say principle is the same. Because to ensure fair justice.
But this case was passed, this order was passed under unique circumstances of the case.
Yes.
This case, Bharat Amritlal Kothari,
Ah,
that was in a totally different context.
yes.
Here what had happened was that some cattle was seized. On cattle was seized because of the fact that they were illegally being transported and they overturned, then the cattle was retrieved. And in the writ petition, the orders were passed.
Well-
Amounting to conviction
Yes.
under 226, although the 482 was never invoked. So it's under those circumstances that this court
Well, that-
intervened.
But then the principle remains the same one. It is a general principle enunciated by the court. Kindly see. Otherwise, what will be the effect as I submitted? This inquiry pertaining to whether this course which has been in practice being conducted by the Beach Pilani since 2079 is a course which was approved by the authorities, which was legally pursued. And if to be declared illegal, then in that case, what will happen to it?
In short, we can come back.
All the affected persons otherwise will be required to be heard, or an opportunity should be given to them. More particularly the institute which is running the course and granting, they are the best person to answer. What is the foundation? It is not there. My lord, in that context, lordship may also kindly take up under this judgment. Two 2010-11 SCC,
This is on what proposition?
the same proposition, my lord. That
It's okay, we'll take note of it. If it is same proposition, you may not read it.
I will refer to only paragraph
Paragraph 30, you are saying,
30 to 34,
30.
30 to 34,
Okay.
and also 38 and 39.
Yes.
Therefore, by respectful submission,
Court cannot grant relief which has not been specifically paid
yes,
for.
paid for, which is not the core subject of the petition. And then, lordship, I have on the last occasion.
You have also cited 2008-17 SCC 491. It is on the same proposition.
Same proposition, my lord. Going to
Paragraph 12 and 13.
12 and 13. Yes. Well, my lord, just I'll read out just something here. The object and purpose of pleadings and issues is to ensure that the litigants come to trial with all issues clearly defined and to prevent cases being expanded or grounds being shifted during trial. The same has happened here. Same has happened here. The object is also to ensure that each side is fully alive to the questions that are likely to be raised or considered so that they may have an opportunity of placing the relevant evidence appropriate to the issues before the court for its consideration. This court has repeatedly held that the pleadings are meant to give to each side intimation of the case of the other so that it may be met to enable courts to determine what is really at issue between the parties and to prevent any deviation from the course which litigation on particular causes must take. Therefore, my respectful submission is that this expansion is uncalled for. This expansion is uncalled for. In this given case, this court will only confine to look into whether there was any illegality or irregularity in the selection process, if it was so pleaded. Otherwise, nothing. Otherwise, nothing. And now the question, just for the sake of prima facie satisfaction of this honorable court, the degree is bad. UGC says that this is unheard of degree. My lord, so many things in our life we hear for the first time. Many things are unheard of. Now, at present, so many new degrees are coming, we cannot comprehend this. Like artificial intelligence, computing, so many new things. I have checked out, I have found certain things, lordship will find, maybe tomorrow those will be again here. And those institutes like this felony, who have been considered as the institute of eminence, they are trying to do all that.
Mr. Samwa is not questioning your degree.
No, he says this is bad.
He says it's bad because it is outsourced.
No,
It has gone through.
even then, my lord, what
It
I'm
has
saying,
been done by
This
through a person who is outside the campus.
outside the campus. Even that is also not there. They have their own approval. Therefore, I want to point out one paragraph of their affidavit. Kindly come to page 244. What they have said regarding Ms. Pilani.
244 in which appeal?
350 of 22.
350.
350. Page number?
244. The previous regulator of distance education, namely the Distance Education Council under IGNOU, had accorded ex post facto program-wise approval to work integrated learning program with effect from 1995 to academic year 2007-2008, Dhire number so and so, only to Ms. Pilani Rausa. So they admit. They admit that this ex post facto approval was granted to them by the then DEC. Thereafter, they say that paragraph 13, the answering respondent on behalf of UGC begs to submit that the Bachelor of Science in Engineering Technology has never been a specified degree. Specified degree under section 22 of the UGC Act. Therefore, this said degree cannot be treated as a recognized degree. In my response submission, that this cannot be treated as a recognized degree is also beyond his capacity. This statement goes. Law has said, but equivalent degrees are always there. And university is competent to declare and grant a degree of its own. This is the law. The university, Ms. Pilani, itself declared that this is equivalent to BE. Prima facie satisfaction is there that it was done. Therefore, why the court should go into the roving inquiry, expanding the field beyond the pleadings, beyond the prayer? In its, and I placed it on the last occasion that 548 meeting proceedings. Once more, Lordship may see 284. 284 page. 284. This is the proceedings. That starts at 281, my lord. UGC meeting was held. Entire proceeding is there. Then 284, Lordship will kindly come to the 2.02 down below. To consider, this is the agenda, to consider the recommendations of the Empowered Expert Committee on establishment of new off-campus by institutions of eminence and continuation of work integrated learning program WILP by Ms. Pilani. Specific agenda. Number 1, considered and approved. Further, the Commission approved the recommendations of the Empowered Expert Committee to allow Ms. Pilani to continue with its WILP program. However, Ms. Pilani will have to strictly comply with the UGC guidelines in this regard as and when issued. So, after this, what remains? For the purpose of this particular petition, to say that this argument advanced that this is not a degree cannot be accepted. Is enough.
Okay.
And regarding equivalence, I placed it 289 page. Lordship will kindly see the same paper book. 290, last page. This is the notification by the UGC. Accordingly, the degrees, diplomas, certificates awarded for programs conducted by the ODL institutions recognized by DEC, erstwhile and UGC in conformity with UGC notification on notification of degrees should be treated as equivalent to the corresponding awards of the degrees, diplomas, certificates, traditional universities, institutions in the country. Therefore, in my response submission, my lord, there is no necessity to go into other aspects, and there cannot be a finding recorded as regards the validity of the degree. And that on that ground, the appointment cannot be said to be invalid when there is no other irregularity or illegalities in the selection procedure period or proved. Now, well, the Lordship may also here take note of the statement of the AICTE in their affidavit at page 245, relevant page 246.
You've shown us that paragraph 6 you are referring to.
Yes, yes. Lordship has taken note, I suppose. So therefore, it says categorically, deemed to be university does not require AICTE's approval till Supreme Court opined in 2017. Paragraph 6 last line.
Paragraph?
Paragraph 6, my lord. Last line.
Page 247.
247 page.
First paragraph, last line.
And then also kindly see the last line of the same page, 247, paragraph next, second paragraph. AICTE does not approve distance education program in engineering and technology. The integrated learning program is not a regular full-time course, nor it is a distance education course. This is the malad irony here. They say this is a distance education course. In fact, they say no, it is not exactly distance education. It is not a regular full-time course, nor it is a distance education course as claimed by the BITS Pilani. It is a unique program for working professionals. Others cannot join it unless he is a working person with technical qualification. For working professionals conducted without the approval of the AICTE, the deemed university cannot claim to have approval of the AICTE, but the BITS Pilani claims that the course is approved by UGC. Hence, UGC would clarify. The UGC has said it has granted post sector approval. Even now, it is continuing. Therefore, my lord, in my response submission and to my understanding, there is no necessity to look into or go into or take your lordships to others. They are in this matter.
Mr. Mahantha, we close the matter.
My lord, I will just refer to one thing because they are having upon. Yes. Well, now I will take your lordship to the decision of the apex court in 2018 one SCC, that's the lift irrigation. Because my submission was that there are two groups of institutions. One is the technical institutions who were had the expertise in those courses itself, and they were running those courses in their campus itself. And those are the other group of institutions who are not running any course in technical education, in technical courses, but they are running their courses in some other courses other than technical courses.
Two thousand, lift
18.
irrigation, 2000,
2018,
One is
18.
one SCC,
Okay.
6H.
468. In this case, issue was pertaining to 4 institutions deemed to be universities, namely JRN, Vidyapith, Udaipur, Rajasthan, IASE, Gandhi Vidya Mandir, Sardars Sahar, Rajasthan, and Allahabad Agricultural Research Institute, Allahabad. These 4 were the issues. And Vinayak Mission Research Foundation, Salem. JRN Rajasthan Institute of Advanced Studies in Education, Sardar Sahar, Allahabad Agricultural Institute, Allahabad, Uttar Pradesh, and Vinayaka Mission at internal page of the judgment, my lord. Paragraph 12, my lord. Paragraph 12.
Yes.
It may be appropriate at this stage to quote para 19 of the affidavit filed by Mr. Ved Prakash, Chairman, UGC. It is pertinent to note that while bringing the 2010 deemed universities regulations to the notice of the general public, including the public notice number so and so, dated 27/6/13, annexed as excerpts later in the affidavit, the UGC has also clarified that the UGC has not granted approval to any institution deemed to be university to establish study centers. It is regarding study centers. This is relevant because, firstly, deemed to be university status is conferred on academic programs in specific domains of knowledge. In this case, four deemed to be universities were conferred that status to offer programs in the following areas. These 4 and the areas were specified. Kindly see, my lord. 1, 2, 3, 4, then right-hand column. The right-hand column is social work, education, agricultural engineering, food and national biotechnology, nutritional biotechnology, dairy technology, medical science, dental science, nursing, engineering, and technology science. Yet, 3 institutions deemed to be universities, namely JRN Vidyapith, Udaipur, Rajasthan, IASE, Gandhi Vidya Mandir, Sardar Sahar, Rajasthan, and Allahabad Agricultural Research Institute, Allahabad, overstepped their mandate and started distance education programs, including for award of BE, BTech degrees outside their field of specialization without UGC, AICTE approval. Secondly, Vide letter dated 9/8/2001 annexed in the instant affidavit, UGC has made it clear that franchising of education through private agencies establishment is not permitted. In addition, UGC, AICT, and DEC have issued a joint letter dated 13/5/2003 affidavit annexed to vice chancellors, head of institutions, asking them to limit the system, program of delivery of distance education of their institution to the neighborhood of the location of their main campuses or at the most within the state. And as mentioned earlier, with a public notification that is 26/7/6/13. UGC has started that stated that the institutions deemed to be universities can operate only within its headquarters or form those off-campus offshore campuses which are approved by the government of India. That time they were there, though through notification published in the official gazette. Though UGC has not granted approval to any institutions deemed to be universities for distance education, mainly through franchise arrangements. Then we may skip over. Kindly come to paragraph 25. No.
সেইটো ফাইলত লাগিব হা
Here, Lordship may also see 23.6.3. Just above 25, paragraph. Para 4 and 5 deal with distance education and as prospective approval to the following terms. Distance education, the deemed to be university would offer the distance education programs only with specific approval of the Distance Education Council and the University Grants Commission. As such, any study centers can be opened only with the specific approval of the Distance Education Council and UGC. That was there. Then kindly come to 23.8.
Incidentally, you know, why this will be counterproductive to your first argument. Please come to paragraph 2.
2 of the judgment.
This same judgment. Sorry, 3. Paragraph 3.
Yes. What action? If is it so? No.
The director of lift irrigation, so the service conditions of engineers, including junior engineers, which is the base cadre in the engineering wing. So as amended, junior engineers from feeder cadre. Then we pass over Ravi Shankar Patro, a diploma holder in electrical engineering, joined OLICS junior engineer electrical. While in service, he acquired BTech civil degree from deemed to be University JNN Rajasthan.
Yes.
And then, according to him, he being an in-service graduate engineer was entitled to be promoted to an assistant engineer.
Yes.
The prayer was allowed.
Right.
Correct.
Hmm.
So therefore, the issue before the High Court was whether he being an in-service candidate could have been given promotion. But what the Supreme Court did while taking up the prayer made in the writ petition is that all the degrees were invalidated.
Well, that is why I am coming. Here, Supreme Court found that these 4 institutions, they are not conducting any such courses within their campus
No,
itself.
we understand. But you see, your first argument was in the earlier occasion that when there is no prayer in the writ petition,
Yes.
the court should not digress and go to and answer those queries.
This is the law laid down by the apex court itself. My submission
No,
is
we
based on the
understand.
apex court decision. And here also kindly see, but a Supreme Court power is something different. Supreme Court, Lordship will appreciate. Supreme Court, for the substantial justice, Supreme Court can go beyond. This is always there. Always there. Therefore, but then here also Supreme Court says, here also ultimately Supreme Court said that look, those institutions, these four institutions, they are running courses in humanities and other courses. They do not have expertise, even within themselves. How can they conduct such engineering courses outside? Therefore, What we do, you appear again in some examination, let them hold some examination, you appear, if you pass, then that will be approved. Otherwise, till then, we hold on these degrees.
Yes.
That was the case, well, justice is done. But in case of institutions, universities, deemed to be universities, Supreme Court has not said anything. That was a guideline set that how to go about. But Supreme Court has not entertained, not said anything. Therefore, to ward off any doubt from the mind of your lordships, I have read it.
Not only that, in this judgment, what the Supreme Court did was that all benefits granted were also recalled.
Yes, yes, to those, because those who were found to be illegible. But in those cases, degrees were put to challenge. Degrees were put to challenge. That those degrees could not have been at all granted.
So number one, benefit which is got by the students, those were taken away. The fees which were taken by the deemed universities were also directed to be returned.
Yes, true, my lord.
The clock
Irrespective
is,
of-
the clock
because-
is wholly set back to the original one.
But that was after hearing these four institutions. That was after hearing all concerned parties. Therefore, my question is, their issue was that whether they could have at all granted these degrees. If not, then those who have already got benefit of those degrees, then definitely court will say. But here it is not there. Here it is not there. Therefore, my respectful submission, my lord, every case has to be decided on the facts of its own. What they have asked for, what the petitioner has asked for, what he could have further asked for, did not ask. Therefore, whether that can at all be granted. I said, my lord, had it been a case that at the very initial stage of the advertisement itself, somebody has come challenging the advertisement that this qualification they have mentioned cannot be entertained, then the matter would have been different. But not at the stage at which the prayer with which the petitioner has. Paragraph 27, my lord, that is, they even had it ex post facto approval. Supreme Court says that even those institutions, they have named those institutions, had no expertise or specialization in the fields of technology, engineering. None of these three deemed to be universities was having any regular engineering college or faculty in technology engineering at their own campus. So that was the particular fact which led the Supreme Court to decide the whole issue. This apex court will rely upon heavily on Bharati Darshan case, university. This at page 25, paragraph 25, Lordship will see what the Supreme Court has said. Paragraph 25. On 24/9/2001, a decision was rendered by this court in Bharati Dasan University versus AICTE. The appellant therein created under the Bharat Dasan University Act with its area of operation over 3 districts in the state of Tamil Nadu had commenced courses in technological subjects in its own departments as an adjunct
to the university without any approval of AICTE. A writ petition was filed by AICTE submitting that no such courses could be started without requirement for a university to start courses in technical education. This court held that the definition of technical education under the AICTE Act includes a university, and since the power of grant of approval for starting new technical institution and for introduction of new courses or programs under Section 10K of the AICTE Act would not cover a university, quote unquote, but only a technical institution. The applicant university was within its rights to start such courses without the prior approval of the AICTE. Universities are not required. The other day I placed it. Lordship has taken note of. Universities can. Bharat Dasan, having laid down that prior approval of AICTE was not required for a university to start technical courses, the subsequent guidelines notification issued by UGC, AICTE and the Government of India were framed in the light of the said decision. The understanding entertained by all the authorities was that AICTE was not competent to deal with issues of prior approval in respect of universities, quote unquote, for technical courses. And since the term university under the UGC Act includes deemed to be universities, AICTE has no power to deal with issues for prior approval of technical courses in respect of deemed to be universities as well. Therefore, 27, we now turn to the aspect of consideration by the authorities concerned for request of grant of ex post facto approval of courses in technology, engineering conducted by deemed to be universities, namely JRN Rajasthan Vidyapith, Rajasthan, for short, Institute of Advanced Studies in Education, Rajasthan, Allahabad Agricultural Institute, Allahabad, and Vinayakam Mission Research. None of these deemed to be universities had taken any prior permission from any of the authorities, namely UGC, AICTE, and DEC, nor had they even intimated at any juncture the fact that they were conducting such courses in technology, engineering through distance education mode. Pertinently, JRN, IAS, and AAI had no expertise or specialization in the field of technology, engineering. None of these three deemed to be universities. None of these three deemed to be universities was having any regular engineering college or faculty in technology engineering at their own campus. When they commence courses in technology engineering or distance education mode through study centers all over the country, the facts stated hereinafter narrate how their applications for ex post approval were dealt with, and by way of illustrations, the facts pertaining to JRN are dealt with here. So in their case, Supreme Court said this post facto approval was also not valid, because Supreme Court elaborated and took as an example JRN in their case how it was granted. We can skip over that part. My lord. You want to say something? No, my lord, I'm
Helping you in
on
any manner, we don't find this judgment.
this judgment.
You see because the main part which hits you is the invalidation of the degrees. But the other part doesn't help you because of the fact that in this case, Supreme Court asked them to have a committee, the AICTE had a committee, and then they said that in order to protect the innocent students, they were permitted alternatives. Two alternatives were proposed. So perhaps this way it doesn't help you in any way.
My lord, my response submission is, those facts, those issues are not before this honorable.
Yes,
Therefore,
take
therefore,
out of the
how
file.
the Supreme Court considered those issues by giving opportunity and hearing all the affected institutions.
No, what the Supreme Court did was an original exercise, because what
Yes.
it was, it implemented, and then it also, in one of the paragraphs you will find that it also dictated what would be the issues, and then started to decide that matter.
Yes, yes, because he expanded, Supreme Court has expanded and gone into, because of substantial justice, if finds that something irregularity is going on. But what I am placing before your lordship is, going by the facts, I mean the documents, evidence available before this honorable court on this petition, there is a picture which clearly comes out to the extent that P.H. Pilani is a deemed to be university with specialization in technical courses and having the status of eminence in the country. And what is the powers, what is the purpose of declaring eminence? That regulation, UGC regulation 17 has categorically said. I have placed it. University Act also says, this Supreme Court has also noted that universities are not required to take approval even from the AICTE. They can themselves designate, they can themselves conduct courses. In this even gone, this 2017 regulation I have placed, even distance education courses also allowed to be conducted by them. Probably taking into account all that the Supreme Court granted. I mean, the UGC considered it. The institutions of eminence deemed to be university may offer courses under distance mode without any approvals. My lord, 19.0. In accordance with the minimum standards laid down by the Commission. The provision shall also is applied to government-owned and controlled deemed to be universities which have been declared institutions of eminence under UGC declaration, so and so, so and so. Therefore, now the things have changed. And had it been the case that this degree which was granted, BS Engineering Technology, has been granted by an institute which has no expertise in the field, of course, then probably the court could have expanded the issue and could have gone into. The statutory authorities, UGC's post facto approval, UGC says that we have nothing to do there. I mean, the AICT says we have nothing to do there. UGC can. So UGC says we have granted approval. It is being run now. And this is, AICT has made it clear, this is not strictly a distance education mode or not an in-campus also. It's a unique program. It is done with professionals who are in service with a mentor. Therefore, it's a new innovation. The university declares it that this is equivalent to B. Therefore, on that fact, this is a fact coming before this honorable court clearly. And going by the prayer and the writ petition, therefore there is no necessity to go into that aspect. Lordship may be pleased to hold that apparently on the basis of the facts, this issue is not there even then. Lordship may record a satisfaction, if so likes, that this issue, our prima facie view is this. Lordship may say that. I think that what I can only submit before your Lordship. Supreme Court's power is unlimited. Because the Supreme Court. Finally, the Supreme Court, while I was arguing a execution case, Supreme Court says, well, a High Court has also dismissed and review was also dismissed. How are you affected? I submitted. Supreme Court said, look, I know we can understand that you may not be happy because something is there, but you have got substantial justice to that extent. Why should you enter into it? Sorry. So question on this, they limit it because they're basically a constitutional court. Therefore, in other cases, court is definitely to some extent limits itself. But so far the constitutional issues are concerned regarding involving the society as a whole, there obviously Supreme Court has it for. But otherwise, Supreme Court has laid down the guidelines for us, my lord. That's why I'm placing. Lordship will be pleased to consider.
Well, I want to, just one line reply, my lord. What,
I think
one
every good
sentence.
thing must stop.
must one line,
To an end.
That's
one line, my lord.
Yes.
No, one line, my lord, because I have to
No.
pursue.
Reply to reply would be, again, we'll have to.
Well,
give-
just one sentence, my lord. That-
No.
what
Then
I-
we'll have to give permission to Mr. Mahanta also to submit.
Yeah, exactly. No,
Precisely.
I'm just taking a cue from his argument.
No. Everything must come to an end.
Deeply applied.
The submissions. You adopted the submissions of Mr. Mahanta.
Fair election process, and the writ petitioner, he came before this honorable court lordship, being unsuccessful candidate. That submission may be recorded. Otherwise, other law points already covered by my learned senior. I'm adopting those submissions. lordship.
The the reply submissions by Mr. K.K. Mahanta and senior counsel, assisted by Ms. N. Begum, learned counsel for the appellant in WA 350 of 2022 and respondent number 4 in WA 142 of 2023 is concluded. Stop. The submissions of Mr. S. Sutradhar, learned counsel for the appellant in WA 142 of 2023 is also concluded. Next para. Mr. A. Samwat and counsel for UGC, respondent number 4 in WA 350 of 2022. As well as Mr. Pankaj Das, the private respondent in person in both the appeals are also present. Next, judgment reserved. Anybody we have left out? No.
Well, names have already been given.
Oh, okay. Some names.
Yes, of course. Yes, sir.
Deeply.
Should come to that vote.
Nine to 56 for hearing.
Yes.
Today is a wonderful day. Before you start playing, everybody is retired heart.
Yes. No audience. No.
No, Mr. Hazarika is here. I am sorry. I take it back.
Well, yesterday, I placed the first point. The first point is that there is an order by governor which says that I have completed my probation period. And then I have also shown your lordship the circumstances in which the extension order was passed on 20th of January 2018. And
Your Lordship's one question was, what will be the effect if an order is not published in the official gazette, although it is required to be published? Yesterday I said, my lord, it is for the information of all. And it is also for authentication of that order, that such order is in fact being passed. Now, that is not before your Lordship. They took time before the court number 1 at that point of time, but they did not produce and they say it is not there. That's what I remember, they will say now. Then, my lord, I referred to the second point, I came to the second point, and I referred the affidavit in opposition, which is page 3 of compilation 2. This is by one Ikramul Hussain, Joint Secretary, wherein he did not hide anything. He straightway narrated under what circumstances these orders were passed. He also said, my lord, these orders were passed on a letter written by the Superintendent of Police, Dibrugarh. His Lordship has witnessed. Now, I also submitted before your Lordship that initially all the orders, discharge orders, contain details. At the time progressed and they became wiser, then, my lord, they cut short. They reduced the order and removed all those parts which would have on the face of it shown that it's an order, it's an stigmatic order. And they passed an order simpliciter. I had placed before your Lordship earlier orders, and I also told my lord that there are 3 other orders at page 10, 11, and 12 of compilation number 2, which will show it contains detail of the circumstances under which the discharge order is passed. And then I placed, my lord, the discharge order which is passed in the present case, and that your Lordship will get at page 134, if I remember correctly. Is it 135? If your Lordship can have this paper book.
135 of the
Paper book.
the bigger paper.
Writ appeal 196. Writ appeal 196.
Yes. This one?
No, it's the appeal memo.
Oh, memo appeal. Okay.
Sabira Imran.
Item
32.
Item 32, Sabira Imran. At page 35, 135 below. This is simple discharge order. It contains no allegation, nothing. It simply says that Governor of Assam, in exercise of power conferred under Rule 16B of the Assam Police Service Rules 1966, is pleased to discharge Sabira Imran, APS, Probationer, Assistant Commandant, so-and-so, so-and-so, from service with immediate effect. So they tried everything to make it look as if this is an order simpliciter. There will be contrast between the two orders. Then, my lord, I took your lordships through some of the paragraphs of the writ petition of Sabira Imran. Especially if your lordship has noted, I referred to paragraph 48. I referred to paragraph 48, 60, 73, and 75.
Yes.
That your lordship had made a note of it.
Of the judgment in?
My lord?
Of the judgment in?
Not judgment.
Not judgment. This is the affidavit in opposition.
Oh, acha, affidavit. Yes, 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 affidavit.
25-7. Because I wanted to show what is their case. And then,
Affidavit in opposition of respondent number 2 and 3.
yes. I referred, my lord, paragraph 48, 60, 73, and 75.
Paragraph 48,
60,
60,
73,
73,
and 75. 75, second paragraph.
77 also, I think. No.
I don't remember. But maybe that also is relevant, but I wanted to cut short. Otherwise, 65 is also, my lord, relevant. But I just wanted to cut short because of the paucity of time. Now, my lord, I was to start with the Samshed Singh's case. At that point of time, the time was over, and Mr. Kohli also said that your lordship has fixed only till 1. Then I said it will take some time. So I will pick up the thread from here. And my lord, I heard Digonto Das perhaps said that I'll take half an hour. No, it's not, I never quantify my time because I myself don't know. I don't rehearse how much time I've taken. But I'll try to do it as fast as I can. Now, my lord, the first decision on the point that a probationer is also protected.
English, when you use E in expendable,
My lord,
that carries a different meaning. But when you write A, expandable,
it is not expendable. I want to place everything before your lordship because, my lord, what I have noted, with all respect to my learned friends, very vital points have not been placed before your lordship. And I will say, for example, I will, my lord, give your lordship. Justice Krishna Iyer, your lordship asked me motive and foundation. Your lordship asked me the difference. My lord, Krishna Iyer has beautifully described it in Dipti Prakash Banerjee's case, which was placed by my learned friend Mr. Das, but he did not place it. He just read one, I will say, he just read one paragraph. My lord, any live nexus between the alleged misconduct and the order of dismissal or discharge will amount to punishment. So, provided there is a live, if I am able to show your lordship that there is live connection, I will place that in detail. The first case that I am placing before your lordship is
No,
Samshed
because
Singh.
once you are giving very emphasis on that,
Yes,
so I thought that it would be appropriate to ask you the difference. Otherwise,
it's
I
very important.
I would not understand the meaning.
It's very important, my lord, to know the difference. And that I will start, my lord, from the Justice Krishna Iyer's judgment. My lord, the first case today.
It is better to ask than to
Absolutely.
feigning.
Absolutely, my lord. So many things we don't know. And I don't hesitate. I ask you, my juniors, tell me. My lord, some judgment is added in today, and we have sent it to
Mr.
we have-
Kohli, before you joined, we were just telling Mr. Mishra, you have seen the courtroom scene today, except for Mr. Hazarika. Everybody is retired hurt. Your voice is not coming, Mr. Kohli. You are muted. No, your voice is not coming. I am not getting your voice. Yes, Mr. Mishra.
My lord, your lordship will, I was telling, my lord, we have added few things here in the compilation today, and we have served copy on Mr. Kohli. Your lordship will kindly turn to page 45 of compilation 2.
Yes. 45.
Yes.
Yes, that is Samshed Singh.
Samshed Singh's case. Only relevant one we have annexed. The next page, if my lords will see, page 46, my lord. I'll place 3 paragraphs, my lord. Paragraph 62, 63, and 64.
62 you have read yesterday. I have marked it. Paragraph
Then-
62, 63, 64.
I've read.
Yes.
Then I'll skip
Because
this.
64 is that you had stressed on, if on the other hand, the probationer is
Yes.
faced with an inquiry and charges of misconduct
Right.
or inefficiency.
Absolutely.
So that's where you stopped.
Now, then, my lord, now the other case that I will
In
cite.
para 62, you are reading this last 5 lines.
Yes, yes.
And in para 63, again, this last 5 lines.
Right.
You gave stress.
Right. Now, today, another case that I will refer is, my lord, Gujarat Steel Tubes Limited. That your lordship will get at page 39 of this compilation. 39.
You are reading paragraph 51.
My lord, 50 to 54. I will place before lordship.
Yes.
Let me begin with paragraph
yes.
50
Yes.
at page 40. The anatomy of dismissal order is not a mystery. Once we agree that substance and not semblance governs the decision, legal criteria are not so slippery that verbal manipulation may outwit the court. Broadly stated, the face is index to the mind, and an order fair on its face may be taken at its face value. But there is more to it than that, because sometimes the words are designed to conceal the deeds of linguistic engineering. What a beautiful word used by Justice Krishna Iyer. Linguistic engineering. So it is beyond dispute that the form of the order of the language in which it is couched is not conclusive. The court will lift the veil to see the true nature of the order. 51, I'm placing, my lord. Many situations arise where courts have been puzzled because the manifest language of termination order is equivocal or misleading, or dismissal have been dressed up in simple termination. And so judges have divided into distinction between motive and foundation of the order and a variety of other variations to discover the true effect of the order of terminations. Ruling are mage. My lord, mage, I have given the meaning, is a complex network of passage or path designed to be confusing. And lordship will get at page 50, 83, lord. 83. My lord, Justice Krishna Iyer's judgment we cannot read without a dictionary. Mage. Your lordship has
We have had our own share.
Yeah, we had. It was so much so
That both parties celebrated.
one day, I was for the petitioner, we were for the petitioner, we were very gloomy. The other side enjoyed. And the next day, we enjoyed and the other side realized what the order was. So we had our own chair.
Mr. Kohli, we are still losing your voice. Some difficulty.
दिल्ली का ये हाल है कोहली साहब. I'm pleasing. Maze is a complex network of interconnected passage or paths designed to be challenging and confusing. So when my lord, this judgment says rulings are made on these questions, and rightly so, it's not very clear, my lord, on this question, but in some, the conclusion is clear. If the two factors coexist and inference of punishment is reasonably, though not inevitable, though not inevitable, if both the factors are there, I'm reading it again, if two factors coexist and inference of punishment is reasonable, though not inevitable, what are they? That's a question that their lordships asked. 52, I'm placing, my lord. If severance of service is effected, the first condition is fulfilled. If the foundation of causa causan, cause of the cause, my lord. The meaning is at page 84, we have given it.
No, causes we understand.
Yes. Of such severance is the servant misconduct is the second conduct, the second is fulfilled. I'll read it again. If the severance of service is effected, the first condition is fulfilled, and if the foundation or causa causan of the severance is servant's misconduct, the second is fulfilled. If the basic foundation of the order of termination is clearly not turpitudinous or stigmatic or rooted in misconduct or vegetates in evil pecuniary effect, then the inference of dismissal stand negated and vice versa. These canons run right through the disciplinary branch of master and servant jurisprudence, both under Article 311 and in other cases, including workmen and under management. The law cannot be stultified by verbal habsdeshery, means, my lord, page
85.
Page 85. Haber. Yes. तुमको लगा दिया ये निकलता है.
Please,
Am
please.
I audible now?
Now, yes. Now, yes.
We figured out the problem, Lordship. But I wanted to tell Mishra, sir, I have to thank him first for sending me all the papers in advance. I'm grateful for that. Second, the share of good language and the celebration story Mishra sir told me in the last round of litigation. But I must say that then I went and read a judgment and realized that yes, Justice Iyer is not the only one whose language requires a dictionary.
Now, haberdashery means, my lord, small item used in sewing machines such as button, etc. So, I'm reading it again. The law cannot be stultified by verbal haberdashery because the court will lift the mask to discover the true face. It is true that the decision of this court and the high courts since Dhingra's case have been at times obscure. If cited the horse full fact, sorry, this is the, at times obscure if cited the horse the full facts. In Samset Singh's case, the unsatisfactory state of law was commented upon by one of us, Justice Krishna Iyer, and quote. Then, my lord, he's quoting Dr. Tripathi's passage from Tripathi's book. In some cases, the rule of guidance has been stated to be substance of the matter and foundation of the order. When does motive trespass into foundation? When do we lift the veil of form or to touch the substance? When court says this Freudian, Sigmund Freudian was a something, he was some expert, my lord, obviously failed in the work a day order, and Dr. Tripathi observes in the context are not without force. He says, as already explained, in a situation where the order of termination purports to be a mere order of discharge without stating the stigmatizing result of departmental inquiry, a search for substance of the matter will be indistinguishable from the search of motive. Failure to appreciate this relationship between motive, the real but unrevealed object, form, the apparent and officially revealed object in the present context has led to an unreal interplay of words and phrases wherein symbols like motive, substance, form, or direct parade in different combinations without communicating precise situation or entitled in the words of facts. The need of this branch of jurisprudence is not so much to reach perfect justice, but to lay down a plain test which the administrator and civil servant can understand without subtly and apply without difficulty. After all, between unsuitability and misconduct, thin partition do their bound divide. And over the years in the rulings, of this court, the ascent has shifted and the canons have retreated. Varied predictability has proven difficult because the play of legal right and shade has been baffling. The learned Chief Justice has in his judgment tackled this problem and explained the rule which must govern determination of the question as to when the termination of service of the probationer can be said to amount to discharge simpliciter, and when it can be said to be a punishment so as to attract inhibition of Article 311 of the Constitution. Master servants cannot be permitted to play hide and seek with law of dismissal, and plain and proper criteria are not to be misdirected by terminological cover-up or by appeal to psyche process, but must be grounded on substantive reasons for the order, whether disclosed or undisclosed. The court will find out from other proceedings or documents connected with the formal order of termination. Your Lordship will kindly mark it. The court can find out from the other proceedings or document connected with the formal order. So any document which find mention in the termination order, the connection is established. This is what I have understood. I'll read it again. This court will find out from other proceedings or documents connected with the formal order of termination what the true ground for termination is. If thus scrutinized, the order has a punitive flavor in cause or consequence, it is dismissal. If it fails short of this test, it cannot be called a punishment. To put it slightly differently, a termination is effected because the master is satisfied of the misconduct and or of the consequence of desirability of terminating the service of the delinquent servant is dismissal, even if he had a right in law to terminate with an innocent order under the standing order or otherwise. Whether in such a case the grounds are recorded in different proceedings from the formal order does not detract from its nature, nor the fact that after being satisfied of the guilt, the master abandons the inquiry and proceeds to terminate. Now, this is what I was saying in the beginning. Given an alleged misconduct, Lordship will see, and the live nexus between it, the termination of service, the conclusion is dismissal. Even if full benefit as on simple termination is given, non-injurious terminology is used. In fact, in Dipti Prakash Banerjee's case, it was found there was live connections between the order of discharge and the alleged misconduct. And I will show my lord from that, and then I will place how we are connected, how that affects us. My lord, the last paragraph, few lines I'll place, 54. On the contrary, even if there is suspicion of misconduct, the master says that he doesn't wish to bother about it and may not go into his guilt, but may feel like not keeping a man, and he is not happy with. He may not like to investigate or take the risk of continuing a dubious servant. Then it is not dismissal, but termination simpliciter. If no injurious record of regions or pecuniary cutback on his full terminal benefit is found. For in fact, misconduct is not then the motive factor in discharge. We need not chase other hypothetical situation. Misconduct is not the moving factor in discharge. पानी दो।
Mishra, we are sending you something.
Yes.
Even dictionaries had to understand.
Yes, he was a psychoanalysis. I couldn't say that. I've read it. I've seen it. It is pronounced as Freudian.
But dictionary meaning is also not very.
Now that is
For
that is there.
for dictionary meaning, we need again another dictionary.
Yes. Yes. We need to go into thesaurus. There are so many words there. We can choose one. But Simon Freudius, my lord, was a psychiatric. He was a psychotherapist. At page 86, I have placed it.
Yes, okay, but
Yes. Page 8. Now, my lord, after Gujarat, your lordship has, I hope I'm very clear, that if there is live nexus between the order of discharge and the alleged misconduct, then it is a dismissal from service. That is the, my lord, crux, according to my submissions, of the judgment passed in Gujarat Steel. Now, one small, my lord, at page 48, if your lordship will come, Chandra Prakash Shahi, because it was relied upon by the other side. I had relied for different purpose.
just repeat that again. If there is a live nexus,
My lord, if there is a live nexus between the discharge or dismissal order and the alleged misconduct,
then you say it is termination.
yes, this is what, my lord, in paragraph 53 of Gujarat Steel at page 41, last 4 lines. This is what is mentioned. And I'm putting it simply, my lord, as I have understood. My lord, one more decision is at page 48. The first compilation, my lord. I'm sorry, my lord, the first compilation. Yes. Your lordship will remember this case where there was a specific regulation, UP Police Regulation, paragraph 541, which says
You
that.
referred to yesterday.
Yes, but that was, my lord, the learned single judge has relied on this. I'm relying, I also placed this decision, which is unfortunately not written, paragraph 12 at page 56. Just few lines to show, and it's nothing new. It is already given in Purushottam Lal Dhingra and also Samsher Singh. But few lines I'll just read, my lord. At page 56, paragraph 12.
Yes.
12 at page 56. Just few lines, my lord. Page 56.
Yes, we have it.
Now it is well settled that temporary government servant or probationers are as much entitled to protection of Article 311(2) of the Constitution as permanent employees, despite the fact that temporary government servants have no right to hold the post and their services are liable to be terminated at any time, giving them month's notice without assigning any reason, either in terms of the contract of service or under the relevant statutory rules regulating terms and conditions of the service. This is what Purushottam Lal Dhingra said, and even Samsher Singh. Because they are protected if they are discharged on the allegation of misconduct, which is the foundation, then your lordship will interfere. Then now I come to Dipti Prakash Banerjee's case. This is compilation 2, my lord, Dipti Prakash Banerjee. Page.
So just on this Chandra Prakash Sai, yesterday you quoted paragraph 9, today 12. 9 is only 2 paragraphs.
Paragraph 9 was by the.
No, we understand, but.
Yes. 9, 10, these 2 paragraphs. 9 is, the rule is quoted there, 10 is the finding. Today I'll again, my lord, I'll refer to Dipti Prakash Banerjee. Page 63
This is
of this compilation.
volume 2.
Yes. My lord, for facts, it will be required to put the facts in brief. Page 68, if my lords will kindly take up paragraph 3. Paragraph 3.
Yes.
The appellant was appointed on 11/1/1995 as office superintendent in the respondent organization, namely so-and-so. The order of appointment dated 11/1/1995 stated that the appellant would be on probation for 1 year, that he might be confirmed after a year provided the administration was satisfied with the quality of appellant service. Now, this was the appointment letter. Well, from time to time, advices were issued to him. The relevant advice your lordship will find at paragraph 5 at page 69. But this is the reason for his termination. Subsequently, paragraph 5. On 30th/4/1996, the appellant was informed that he was on probation and his confirmation would be considered soon. On 15/4/1996, the director wrote another letter stating as follows. I'll just place one. It appears that your attitude concerning the guest of the guest house has not shown any improvement. Dr. R. Bhatt fell sick with chicken pox and was in quarantine for 3 weeks. You were nowhere to be seen, and the AO was also not seen to take any interest. Similarly, when a Canadian professor fell sick, you were not to be found. Now, this was the allegations on him. Now, thereafter, my lord, he was discharged. Page 72, if your lordship will come to it starts for paragraph 14 and 9, because this is the background in which his services were terminated. Page 72, sub para 9 or para 14. Under the circumstances, your lordship got it. The management is unable to confirm your service in the center, and as such, management is unable to continue your service on expiry of a stipulated period of probation on 1/5/1997, and your service shall stand terminated after the close working hours on 1/5/1997. In case you want to appeal against the decision, you may appeal, etc., etc. Now, the letter that was the offending letter, my lord, is dated 30th/10/1996, which I have referred, my lord, in paragraph 5. In paragraph 5. Now, I'll, my lord, place paragraph. I'll place, my lord, paragraph 23 first. '23 at page 75. my lord. This starts for point number 2. In the present case before us, the order of termination dated 30th/4/1997 is not a simple order of termination, but is a lengthy order which we have extracted above. It not only says that performance during the probation is not satisfactory, but also refers to a letter dated 30th/4/1996. The letter, my lord, where it is written that you did not attend the patient and other guests, by which the period of probation was extended by 6 months from 2/5/1996 and later dated 17/10/1996 and 31/10/1996. It concludes by saying that the appellant conduct, performance, ability, and capacity during the whole period of probation was not satisfactory and that he was considered unsuitable for the post. I'm placing 24 now. The contention of the appellant is that if the appellant is to seek employment elsewhere, any new employer will ask the appellant to provide the copies of the letter dated 30th/4/1996, 17/10/1996, and 31/10/1996 referred to in the impugn order, and that if the said letter contains findings which are arrived without full-fledged departmental inquiry, those findings will amount to stigma and will come in his way of his career. This was the submission. Next point. In the matter of stigma, this court has held that effect which an order of termination may have on a person's future prospect of employment is a matter of relevant consideration. In 7 judges bench decision in Samser Singh, Chief Justice Ray observed that a simple order of termination was passed that would enable the officer to make good in other walks of life without stigma. It was also stated in Vishanlal Gupta's State of Haryana that if the order contains a stigma, determination would be bad, for individual concerned must suffer a substantial loss of reputation which may affect his future prospect. The last paragraph on this point. There is, however, a considerable difficulty in finding out whether in a given case, the order of termination is not simple order of termination. The word used in order can be said to contain a stigma. The other issue in case before us is whether, even if the words used in the order of terminations are innocuous, the court can go into the words used or the language employed in order or proceeding referred to by employer in the order of termination. Now, thereafter, my lord, I will take your lordships through paragraph 18, 19, 20, and 21. Ultimately, what has happened? Because Gujarat Steel was relied, my lord, for the proposition that if there is a live nexus between the order of discharge and the alleged misconduct, then it will be by way of punishment. I'll place 18 first at page 73. Funny. Page 73, I'll refer to paragraph 18. On what basis, on the basis of above contention, the following points arise for consideration. In what circumstances the termination of a probationer service can be said to be founded on misconduct? And in what circumstances could it be said that the allegations are only the motive? When can an order of termination of a probationer be said to contain express stigma? Can a stigma be gathered by referring back to proceeding referred to in the order of termination? My lord, this will be important for our case. I'll read it again. Can the stigma be gathered by referring back to the proceeding referred to in the order of termination? And for, of course, to what relief? Paragraph 19, I will place, my lord. Point 1. As to in what circumstances an order of termination of probation can be said to be punitive or not, depends on whether certain allegations which are the cause of terminations are motive or foundation. In this area, as pointed out by Justice Shah in Madan Gopal versus State of Punjab, there is no difference between two cases where service of a temporary employee are terminated and where probationer is discharged. This very question was gone into recently in Radheshyam Gupta versus State of UP State Agro-Industrial Corporation Limited, and reference was made to the development of law from time to time, starting from Purushottam Lal Dhingra versus Union of India to the concept of purpose of inquiry introduced by Justice Shah, as he was then, the State of Orissa versus Ram Narayan Das, and to the 7 judges bench of Samsher Singh versus State of Punjab and post Samsher Singh case law. This court has occasion to make detailed examination of what is motive and what is foundation on which innocuous order is based. Now, paragraph 20, Gujarat Steel is quoted, which I have placed before your lordship, and 53 is quoted, my lord. I'll again read it out, my lord, for your lordship.
Not required. You can skip that.
Your lordship will just mark the last 4 lines. Given an alleged misconduct at page 74.
74, yes. Given an misconduct and a live nexus.
Yes.
Yes.
The lordship will mark it. Because this is the crux. Then I'll place below as to motive from precetum E, because 53, 54 I have already placed before lordship. Just below that, precetum E. As to motive, one other example is the case of State of Punjab versus Sukhrai Bahadur, who was a charge memo for regular inquiry was served, reply given. At that stage itself, the proceedings were dropped and simple termination order was issued. It was held that the order of simple termination was not founded on any findings as to the misconduct. In that case, the court referred to so-and-so, where a charge memo was issued, explanation was received, an inquiry officer was appointed, but before the inquiry could completed, proceedings were dropped and a simple order of termination was passed. The reason for dropping the proceeding was departmental proceeding will take much longer and we are not sure whether after going through all the foundation, we will be able to deal with the accused in the way he deserves, the termination was upheld. It's a case of departmental inquiry against the probationer, and the employer says, why should we go into? We'll simply terminate him with simplicity. 21, I'll please. If the finding arrived at an inquiry as to misconduct behind the back of the officer or without regular departmental inquiry, the simple order of termination is to be treated as founded on allegations and will be bad. But if inquiry was not held, no finding was arrived at, the employer was not inclined to conduct an inquiry, but at the same time, he didn't want to continue with the employee against whom there are complaints. It would be a case of motive and the order would not be bad. Similar is the position if the employer didn't want to inquire into the truth of allegation because the delay in the regular departmental proceeding or has doubtful about securing adequate evidence. In such a circumstances, the allegation would be a motive and not foundation, and the simple order of termination will be valid. Now, my lord, will see ultimately what happened in this case. Yes. Now, the ultimate finding your lordship will find at page 81. Here again, the live nexus will come. Page 41, page 81, paragraph 41, I'm sorry. We shall next take up the second aspect relating to stigma. We shall assume that the words used in impugn order do not contain any stigma, like our orders, my lord. We shall then refer to 3 other letters to which the order make a reference. The order makes a reference of 3 letters. In the first letter dated 30th 4/1996, we do not find anything objectionable. Coming to the next letter, we however find that para 3 refers to a scuffle between the appellant and one P. Chakravarti, regarding which the appellant made a complaint on 28/5/1996. An inquiry committee said to have been appointed and it gave its report. The extract from the report of the committee dated 15/7/1996 is found in the counter of the respondent. Even counter was considered, your lordship will see here I have shown, taken to your lordship through the counter affidavit. The inquiry committee found appellant's behavior reprehensible and confirmed that the appellant was involved in a scuffle and did mislead, like obtaining false signature, and the said appellant was guilty of inefficient performance or duty, regular attendance without permission, rude and disorderly behavior, and willful insubordination, whatever may be about other words and the other words used in connection with the finding of the inquiry committee about a scuffle, about appellants obtaining false signature, are in our opinion clear in the nature of a stigma. Further, inquiry committee said that he must be punished, and it did not say that the proceeding or disciplinary actions were to be initiated. Thus, on the ground of a stigma also, the impugn order is liable to be set aside. Now, your lordship will see they found out from the 3 letters which were there and got the life connections. Now, my lord, I ask a question. What is there, my lord? In this case, I have already shown your lordship the termination order, the discharge order at page 135 of the paper book. Your lordship will kindly see, because a little mistake might expose or leads, my lord, to something. And that mistake has been made despite the expertise on whose advice these orders, which were earlier differently worded and now differently worded. Your lordship will see the government of 135. The governor of Assam, in exercise of power conferred under Rule 16.
Just a moment.
Oh, I'm sorry.
The appeal memo.
Appeal memo, my lord.
Wanted.
Yes.
The Governor of Assam, in exercise of power conferred under Rule 16B of the Assam Police Service Rules 1966, is pleased to discharge Srimati Sabira Imran, APS Probationer, Assistant Commandant 12 APBN Jamguri Biswanath Charali, under suspension from service with immediate effect. The moment I apply for a job, they will say, oh, you were under suspension when you were discharged. Bring the suspension order. And if I bring the suspension order at page 134, what it would reveal? I'll place 134, my lord. Your lordship stopped me when I was placing, saying that everyone has placed others. Let me place now in the facts of these circumstances of this, the decision that I have placed. At page 134. Whereas a report has been received from the Superintendent of Police Dibrugarh by number so-and-so dated 15/11/2017, that Srimati Sabira Imran, APS Assistant Commandant 12 Battalion Jamguri Biswanath Charali, has been arrested in connection with Dibrugarh PS case number so-and-so of the Prevention of Corruption Act and section so-and-so of IPC, which is unbecoming of a police officer. Now, therefore, the governor is satisfied that it is necessary and in the interest of public service to place Sabira Imran so-and-so under suspension with effect from so-and-so. My lord, if this is placed before, this can be traced from the discharge order, and if we are asked to place this, who is going to employ her? Her whole life is ruined. Because there is a life connection between the order of discharge and the misconduct, which was foundation. And similar things are there in Pallavi's matter, my lord. Lord, for a second, because I have to come back again, I don't want to come back. Pallavi's case, if your lordship will take up item 11 here, just the paper book.
Table 98.
Just the paper book. I don't have to read it, I'll just show it and your lordship will know the similarity between the two orders.
We have it.
Your lordship. Then your lordship will see at page 70. 70 is the discharge order. Again, my lord, your lordship will see under suspension. Your lordship may just mark it under suspension. She was discharged when she was under suspension. And then your lordship will see the suspension order at page 69. It is verbatim reproduction of the suspension order which I read in case of Sabira Imran.
Which page?
69. 70, your lordship has seen the discharge order. 70.
69 is that?
69 is the suspension order.
Same.
It's verbatim reproduction rather. Now I come to the state affidavit, my lord, what they say about motive and foundation. Yes, my lord will find same affidavit in opposition, my lord, on behalf of 2 and 3, dated 25/7/2019, page 144. Relevant paragraph is 64.
144 of 98.
98, yes.
196.
196. That I had shown, my lord, just for this.
Okay.
Otherwise, this 196.
We come back to 196.
Yes. That was only for that, just to show the similarity between the two, the live nexus.
Which page here?
My lord, 167 is the relevant page. I'll place paragraph 64.
This is part of that affidavit in opposition.
Yes, affidavit in opposition dated 25/7/2019 starts at page 144 of the paper book.
Yes.
Relevant is page 167, paragraph 64.
Yes.
It is most respectfully submitted that it is always open to the state as an employer to have regard to any preliminary inquiry, including the investigation carried out by the police in the present case. Such materials would form the inquiry report and others, which said that such material would form motive for discharge of the petitioner. I have just placed, my lord, Dipti Prakash case. Motive for discharge of the petitioner from the service and not foundation thereof. As such, discharge order cannot be said to be stigmatic. Any contention to the contrary would be unsustainable in law. This is a bare denial, and without explaining what is motive and what is foundation. They just say. Now, very interesting finding by the learned single judge that I will place before your lordship. This is the impugned judgment and order dated 18th of March 2020, which starts at page 187. And the relevant paragraph 47, your lordship will find as 284.
Yes.
I'm reading at page 284. Indeed, there can be no hiding from the fact that the arrest and material collected against the petitioner following FIR dated 27/10/2016, registered as Dibrugarh PS case number 936 of 2016, had set the ball rolling. The investigating report of Dibrugarh police were foundational facts. Lordship kindly mark. Foundational facts and gravity of which was considered by the government of Assam in Personal Aid Department, which eventually resulted in the impugned order being passed, preceded by consultation with the concerned department, obtaining the views of the department with approval of the highest government authority. Now, my lord, in my humble submission, what is more is required? There is a finding, and there is no cross appeal against this finding. That is the foundation. Dibrugarh police case is the foundation. And I have shown the live nexus between the discharge order and the misconduct, alleged misconduct. Now I'll place further few lines. But I've divided this paragraph into two, otherwise there will be repetition. The foundational facts I have given. Then I'll continue for few more lines. The impugn actions at page 285, the impugn actions are only in respect of identifiable group / section of candidates who appeared in the main examination. The identifiable group are only those candidates where their duplicate answer sheets after substituting their original answer sheets were recovered from the confidential branch of APSC as well as from the house of the chairman Rakesh Kumar Paul. This identifiable group alone were discharged from service against whom charge sheet have been filed. This further cements, my lord, that the discharge order is a cloak in guise of the order simpliciter, but in fact, it's an order of punishment for this purpose. The rest, my lord, I will place when I go to the next point. Now, your lordship has seen there is a statement that action has been taken only by the identifiable section of the candidates. The question that I ask myself, who has identified? Because if your lordship says it is said today, I will place before your lordship the Punjab case. Punjab case doesn't start with Joginder, Inderpreet Kohlan. It starts with Amarbir 1, then Joginder, then Amarbir 2, then Joginder. So your lordship, in that case, in my lord, a committee of judges. Just in my lord Joginder Singh case, I'll place it later, not now. The other points are also involved. On the direction of the Honorable Supreme Court, Honorable Supreme Court directed that the High Court to constitute two committees, one for the judicial officers, one for the executive officer, and find out who are tainted and who are not tainted. Because if your lordship remembers, the entire selection was cancelled, which the Supreme Court set aside. They said, no, you find out who are tainted and who are not tainted. And that will be done by a committee. But the High Court in Amarbir Singh 2, they constituted a committee of 3 judges of the same High Court. It's very high power, I will say, committee. Nobody can even think of doubting when the committee says something, of 3 judges. They have no personal interest in the matter, and they are knowledgeable persons. So in that case, the identification of tainted and non-tainted was by the High Court judges themselves. In this case, who has identified? That's a question that I ask myself. Police, no one else. Then, my lord, I will take your lordships very briefly through the allegations, because it is mentioned in the judgment that our answer sheets were not printed in the government press. Only on that. And just to show that if an opportunity was given to us, we would have explained it. My lord, we'll kindly come to supplementary charge sheet at page. Your lordship will take up the compilation we have given in compilation 2. Page 17. ma'am.
Page 70 is.
17.
The stick file.
This
Stick file.
the compilation.
17.
17. Otherwise, it is at page 87 of the main
Right,
paper
okay.
book. My lord. Your lordship will find this is supplementary 2 charge sheet. The date is 4/1/2018. This is before our discharge from the service.
Charge sheet number 3.
Charge sheet number 2, my lord.
Supplementary.
Just at the at page 17 only, my lord.
Charge sheet number 3. It's written.
Is it? It's written 7 if your lordship will see. Serial number 7 is charge sheet original supplementary 2.
Okay. In column 2, it is written charge sheet number 3 of 17. That's right.
My lord.
So in charge sheet number 3, this is supplementary 2.
This is my lord charge sheet number, the original charge sheet number, the original. This is supplementary 2. Pallavi is not here. No?
I mean, that's
We have the original charge sheet, my lord. Your lordship also has this.
Paper book 1.
Paper book 1. It's original is 3.
No, that's okay. I was not knowing this. I was reading that column 2. That charge sheet number.
Yes. Now page 18, if your lordship will turn to. This is in respect of accused number 18, Sabira Imran. Similar is the case with Pallavi, my lord. Similar. She is also in supplementary 2. She is in supplementary 6. Pallavi. But same. Now, my lord will come to page 19, the allegation. The allegation. During the course of investigation, Sabira Imran, accused 18, Assistant Commandant 12 AP Battalion, Jamuguri, Sonitpur, was arrested on 8/11/2017. Based on below noted evidence. During the investigation, arrested accused Pavitra Kaibatra, Assistant Controller of Examination APSC, made an extrajudicial confession. Your lordship will kindly mark it. This is the depth of knowledge of the investigating officer at whose, my lord, on whose basis of whose report I have been discharged from service. Made an extrajudicial confession and led the investigation officer to the confidential branch of APSC building and shown the answer script of illegally appointed candidate which Rakesh Paul himself engineered. Accordingly, 36 lot of answer scripts were seized from the examination branch of APSC on 21/11/2016 as led and shown by Pavitra Kaibatra under section 27 of the Evidence Act. This is the extent, my lord, of the knowledge of our police officers. My lord, kindly have 27 of the Evidence Act. Let us, my lord. Of course. Page 55 of this compilation, my lord. It is there. Let your lordship can, I'll also. I'll read 26(7), my lord. How much of the information received from accused may be proved, provided that when any fact is deposed as to the discovered in consequences of information received from a person accused of any offense in the custody of a police officer. Your lordship will mark it. If he is in the custody of the police, where is the question whom he will make extrajudicial confession? Either this person doesn't know that confession, he may be thinking confession is made before the judicial magistrate, and before me it will be extrajudicial confession. The lordship is aware under 167 of the CRPC, the accused will make a statement, he will be interrogated, he makes a statement. Some part of the statement may lead to actual recovery of an object which is connected with the crime. That is called section 27 recovery. Not on extrajudicial confession. So this is, my lord, the knowledge of on 27th of this police.
No, perhaps that is also not complete. Once a statement is there, it must be recorded in the memorandum.
Yes.
Of discovery and
yes. Mark.
then
yes.
recovery made.
Yes, because it is for the purpose of showing to the court that look, this is the exact statement that he has made, and only that part which led to recovery will be admissible. Otherwise, 161 statements are not admissible in evidence. Now he says the entire thing, and the other thing your lordship has marked. Answer scripts are recovered from where? He says from examination branch. Where is the designated place for answer script to be kept? It has to be with the examination branch of the APSC. So what is great about 27 recovery? This is the kind of investigation that has been made. Then, my lord, another your lordship will see B. A I have placed already extrajudicial.
It may be possible that in APSC somebody else is the custodian.
The examination branch, my lord, your lordship will see, and he is also an accused.
No, we understand, but in APSC there may be someone else to have custody.
If it was there, they should have mentioned it. It is not our allegation. They should have mentioned it. Yes. Was voting in the state control. I have to see that. Pavitra Koipatra is the assistant controller of examination. Unless some internal arrangement is made, we don't know. He is assistant controller of examination, and he is kept the answer script with all the answer scripts in the designated place. Otherwise, they should have said that designated place is this, like they have said some of the answer scripts found in Rakesh Paul's. I'm not going on to that. The other thing which I want to point out before your lordship is B. This is just for the purpose that if an opportunity was given to us, we would have pointed out this. B, I'm reading at page 19 only. Forensic examination of the seized answer script revealed that the answer script bearing code number so-and-so of the arrested accused person, Sabira Imran, were not original as these answer scripts were not printed in government press, which is against the rule of examination of the APSC. So, no other reason. It is fake because it was not printed in the government press. Now, my lord, we have shown that the government in our affidavit never prints. They have panel of private printers. My lord, they cannot print regular gadget. I've subscribed. I don't get regularly. Nobody gets, in fact. But they can't print these stationery, my lord. And I will show, my lord, it is part of our affidavit. In Pallavi's matter, we have annexed. It is, my lord, annexed in the same compilation. Page 28, if my lord will kindly come to. Page 28. With reference to the letter cited above, this was an RTI application, my lord. With reference to the letter cited above, I would like to enclose here with a list of firms with address and category registered under the Directorate of Printing and Stationery, Assam, Guwahati for the year 2013 to 2016 as desired by you. And then your lordship will see. Next page, list of firms who are registered and they print. So just because it was not printed in government press, they should have found out where it is printed. Is it printed in the government press or they outsource? But there was no need. And we have been victimized. Now, unfortunately, my lord, these points I have raised before the learned single judge. And the learned single judge, my lord, noted in paragraph 18 of the judgment at page 259 of the impugned judgment. Sorry, my lord, 258. नहीं देखा है ऊपर पे आई करेक्ट कनेक्शन
259.
258. Paragraph 18 starts from page 258. All wearing is required.
Yes. Paragraph 18, your lordship will see. So-and-so submits that FIR so-and-so which set in motion investigation by the Debrugarh police implicates one Navakant Patil, and this FIR does not in any way implicates the petitioner. No separate FIRs have been lodged against any petitioner. Your lordship will come directly to 8th line from the bottom, my lord, on page 259.
Yes.
From the supplementary charge sheet, your lordship got. From the supplementary charge sheet implicating the petitioner, it is stated that there is fundamental flaw in that it cannot be said that answer scripts are never given for printing by outsourcing from empanel of printers. Reference is made to the statement at paragraph 20 of the affidavit in reply dated so-and-so, read with annexure 2, page 43, thereof, which gives list of firms registered under the Directorate of Printing and Stationery, Assam from the year 2013 to 2016. In course of hearing, Mr. So-and-so submitted the name of Subhadeep Printers also finds at serial number 73 in the list produced over to the court. But my lord, subject to correction, my juniors have looked into it. We did not find any finding on this point.
Well, why this Subhadeep is
Because Subhadeep is said to be the brother of Rakesh Kumar Paul. There were allegations at the time of when the counter was made. And then we came up with this. But what we are saying is, just because it is not printed in the government, you can't jump to the conclusion that it is a duplicate answer sheet. Now, my lord, I'll place Punjab case, my lord. The lordship remembers Badal.
We'll have to rise at 3:45 because the single bench of my esteemed sister.
There are a few more things which I will point out to your lordship about the finding of the learned single judge, few things, and few decisions on that point, few more. It should not take more time, but I cannot quantify. On Monday, if your lordship permits me, I'll continue.
You just complete for 10-15 minutes.
Yes, yes.
10 minutes we are here.
I'll try how far I can go.
And you can, since you're the appellant, you will also have a right to reply of whatever he's said.
I will have, but I want to lay down the basic things, because sometimes what happens.
Those judgments, you can give it to the courtmaster with the paragraphs. We'll look into it, even if you don't have the time to place.
That I think very short. I'll not take much time, but those decisions I would like to place, because it will make a difference. It will make a difference, my lord. Let me go through. Your lordship knows I will not take a single minute, my lord, extra than what is required. My lord, in Punjab case, it all started when the chairman was one Rabinder Pal Singh Sidhu, and on raid, I still remember, my lord, it was flash on the TV. The money was recovered from his locker, 3-4 lockers, full of currency notes were recovered. That is how this started. And but before that, I think there was some mistake. On principles of natural justice, first I'll submit, then I'll go to Punjab case. My lord, in Dharampal Satyapal, fortunately, we have a decision. It is by Dr. Sikri, my lord. He, my lord,
really went into the history of the principles of natural justice. Because the other day, my learned friend Arnab Chaudhary was saying that it can be read into that. I cannot place it, but perhaps Rule 19 or something. I'll place that decision first. 2015 8 SCC, page 519.
2015 8 SCC
519. Well, all relevant paragraphs will be 18 to 34, but I'll not read all. 18 to 34. Well, I will read paragraph 19, 20, and 21. And thereafter, I'll go to 23 and 29. Paragraph 19, your lordship will see at page 99. What is the genesis behind this requirement? That is principles of natural justice. Why it is necessary that before an adverse action is taken against a person, he is to be given notice about proposed action and be heard in the matter. Why is it treated as inseparable and inextricable part of doctrine of principles of natural justice? Natural justice is an expression of English common law. Natural justice is not a single theory. It is a family of views. In one sense, administering justice itself is treated as natural virtue and therefore part of natural justice. It is also called naturalist approach to the phrase natural justice, and it related to moral naturalism. Moral naturalism captures the essence of common sense morality, that good and evil, right and wrong are real feature of the natural world that human reasons can comprehend. In this sense, it may be comprehended virtue ethics and virtue jurisprudence relation to justice as all these attributes to natural justice. We are not addressing ourselves with this connotation of natural justice. In common law, the concept of doctrine of natural justice, particularly, which is made applicable in the decision making by judicial and quasi-judicial bodies, has assumed a different connotation. It is developed with this fundamental in mind that those whose duty is to decide must act judicially. They must deal with the question referred both without bias, and they must give an opportunity to each of the parties to adequately present the case. It is perceived that the practice of aforesaid attributes in mind only would lead to doing justice. Since these attributes are treated as natural and fundamental, it is known as natural justice. This principle of natural justice developed over a period of time and which is still in vogue and valid even today. They are rule against bias, then opportunity of being heard to the party concerned, article from partem. These are known as principles of natural justice. To the principles, a third principle is added, which is of recent origin. It is duty to give reasons in support of the decision, namely passing a reasoned order. Now, your lordship will come to a small paragraph 23. 23 is the same page. Aristotle, before the era of Christ, spoke of such principle, calling it universal law. Justinian, in the 5th and 6th century AD, called it jura naturalia, that is, natural law. Then, your lordship, I'll refer to paragraph 29 at page 102. As I said, my lord, this is a beautiful judgment on principles of natural justice, and from paragraph 18 to 34 are all relevant, but because of paucity of time, I'm skipping. Paragraph 29 at page 102. At 28, it is quoted, my lord. D. Smith captures the essence thus, what you got? Where a statute authorizes interference with properties or other rights and is silent on the question of hearing, the courts would apply rule of universal application and founded on the plainest principles of natural justice. So if it is not there in the statute, it has to be read because it inheres. That's the case, my lord. So this is the origin of principles of natural justice. Now the exceptions are there, very well known exceptions. I'll first place, my lord, MC Mehta's case, 1999 6 SCC 237 at page 112 of the compilation. Page 112, my lord. The relevant would be 120. $120.
Yes.
Page 120 of the compilation, my lord. It starts with 112.
Yes.
I'll place paragraph 19 first, that the submission. The learned senior counsel for Bharat Petroleum contended that once natural justice was violated, the court was bound to strike down the orders and there was no discretion to refuse the relief and no other prejudice needs to be proved. It is true that in Ridge versus Baldwin, it has been held that breach of principles of natural justice is in itself sufficient to grant relief and no further de facto prejudice need to be shown. It is also true that the said principles have been followed by this court in several cases, but we might point out that this court has not laid down any absolute rule. This is clear from the judgment of O. Chinnappa Reddy in S.L. Kapoor's case. Principles of natural justice know of no exclusionary rule dependent on whether it would have made any difference if the natural justice has been observed. Well, let's suppose a notice is given complying with the principles of natural justice, but there are, my lord, undisputed facts. No useful purpose will be solved. That is what MC Mehta says. I'll place further. And non-observation of natural justice in itself prejudice to any man, and proof of prejudice independently of proof of denial of natural justice is unnecessary. Chinnappa Reddy also laid down the important justification. I'll come to paragraph 21 first, just 4 lines. It is therefore clear that if on admitted or indisputable factual position, only one conclusion is possible and permissible, the court need not issue a writ merely because there is violation of principles of natural justice. So this is an exception. So I have shown, my lord, the origin. Then I have showed your lordship one exception. The second exception is mass copying or mass cancellation of selection. There, my lord, individual innocence is immaterial. Because if the government decides that there is a situation has come where there is rampant copying or corruption, then the government can cancel the selection or examination, where individual innocence will not matter. And there are decisions, 2 decisions are there. I will not place, the lordship may just note down. One is Bihar School Examination Board It's in compilation one, my lord, page number I will tell. Page 83, we have given from Manu. Page 83. Paragraph 12. Paragraph 12 is at page 85 of this compilation, my lord.
Yes.
This one. And the other case, my lord, is at page 108. 108. Hanuman Prasad and others. This is at page 108 of the compilation. 108. Relevant is paragraph 4, just near precitum F, page 110. The decision is at page 108 and the relevant paragraph, precitum F, is at page 110. Now this, my lord, leaves me the Punjab case, which will not take time. I may not take your lordship through the entire case. And then what the learned single judge has held.
We'll continue then Monday. The submissions of Mr. D. Commissioner and Senior Counsel assisted by Mr. B. Prasad, Counsel for the Appellant, in WA 98 of 2020 and WA 196 of 2020. It's inconclusive. Mr. Kohli, along with his yesterday's names, and Mr. H.K. Hazarika for the state are present. You're also there. Just record your presence. Ms. Chaudhary, you are also there. Ms. B. Chaudhary, Mr. No others are. Tomorrow also, tentatively second half.
Monday, second half.
But we don't know, we have requested the registry to list.
Yes, it is, but it has been rescheduled.
Lordship, I hope my audio is clear. I'm having a lot of problems with internet today in my audio.
Now it is
Monday
clear.
we are in.
Now it
These further things not certain clauses at page 112.
So we're getting it listed tomorrow. Monday.
Monday.
Monday. Our tomorrow is always
Yes.
working day. But Mr. Mishra, please keep a track because you have requested the registry to list few matters so
Yes,
that this APSC matters can be taken up.
Yes.
So it may be possible that we can start earlier also.
We'll be here.
Grateful, Lordship. Very.
It's now louder than required, Mr. Kohli.
Lordship, I must point out I'm on two separate instruments. One I'm using the mic, the other I'm using the video.
No, Mr. Kohli, don't take anything we say in face value. Because
Not at all. And I'm grateful that it's happening like that.
I just want to keep the mood lighter. That's all. I find out
We
ways.
would like to contribute to that too also.
And paying therefore yearly in advance during the next term and do the